Any mention?
Please, Your Lordship, I beg to mention item number 1, 2, and 3, Your Lordship, on behalf of my senior counsel, Mr. Bikram.
Which one?
Item number 1, 2, and 3.
Don't mention, how many times I tell the junior, don't mention order matters, mention hearing matters. Let the matter be called out. Time and time again I've been telling everybody, don't mention order matters on the part 1.
Sorry, Your Lordship.
Yes. How many times the court will say? Even the seniors don't bother to instruct the juniors properly.
Lordship, I beg to mention item number 28, Lordship. I pray that matter may come after 2 weeks, Lordship.
After?
2 weeks, Lordship.
Why?
My senior is out of station, Lordship.
Where's Kharmi?
I've already taken the answer, Lordship.
You want to join? What's the matter about?
This is regarding the termination of the service of the petitioner, Lordship.
You ready?
This case has been conducted by Kharmi, so I'll inform him, Your Lordship.
1 week. We're not going to get this court not give any adjournments just by on the asking. Enough is enough. Yes. 1 week. Yes.
Oh, bless Lordship.
Yes.
May I please, Your Lordship? I beg to mention item number 27.
Why?
Due to some personal difficulties,
Of whom?
Mr. Este.
Mr.
Este.
Sheikh.
Este, Your Lordship.
27.
Yes, Your Lordship.
SD.
Yes.
Where's Mr. SD?
He's due to some personal difficulties, sir.
Where's the petitioner? You informed them?
No, I haven't.
Then you don't mention if you don't inform them. Mention that will come up then. I keep on saying you inform the other side, you take adjournment. Yes, next.
Is the
23, my lord. I'm praying for
Yes?
some. Item 23, my lord.
23. What's the matter about? Why? Today's fixed matter actually. Where's Mr. Chakravarti?
My lord, here we were supposed to work out whether the parties agrees to send this matter for arbitration.
Yes.
My lord, we need some time, my lord.
Lordship, my senior is ready today. He will come.
Let me call out. Let's see if we can do something. Yes.
Hello.
Yes, Your Lordship. Lordship, I beg to mention item number 33.
Number?
33.
Who's for the other side?
I'm for the state, Your Lordship.
Why?
Lordship, same problem is
Same problem?
due to some medical emergency, he has to be in the hospital.
Oh,
So.
Mr. Sasan?
SK Hassan. Yes,
What happened to him?
He has some health issue.
Okay, 2 weeks, yes.
Stay order is there, Lordship. May continue the stay
Just
order.
the order be vacated. Okay. What's the matter about? Any urgency?
Yes, urgency, Lordship. Yet that
Then 1 week. Okay, 1 week. Yes.
2 weeks.
Okay, 2 weeks. Okay, then interim order until next date. Yes.
Much appreciated, Lordship.
Supplementary list, item number 1.
Your Lordship's last order, my lord, we have.
No, why? Because there's some problem with regard to availability of dates. Now we're fixed 6, 7, 8, correct?
Correct.
Now the thing is that on 8th this court won't be there. So whether you take it on 5, 6, 7 or, but then can we issue summons and they'll return it?
There will be a time constraint, my lord. We
That's
might
the
have
thing.
to.
There's a time constraint. So you just consult your, the respondents whether, maybe reschedule it and we can send us, so they can issue the summons before that. So they'll reach in time.
My lord, your lordship will be fixing a date today itself, or
It's up to your convenience. But that's the thing. 5, actually 6, 7, 8 was fixed, but then, so we can take it a week thereafter or?
better, my lord. I think that will give us
Yes.
ample time. 13, 14, and 15, my lord, subject to your lordship's convenience.
So 13, another problem. It has to be on the third week, sorry. You take 19,
19,
20th,
20, 21,
21st, 22nd.
No issue. 22nd. Oh yes. My Lord, we may also be permitted to file one list of witness for summon additional witness.
Of course, at this stage, no problem. You can file the additional list. Due to unavailability of the court in the coming week, this matter has been listed today for refixing the date for examination of witnesses. List of witnesses have since been submitted. Summons also you prepared?
Prepared, Lord.
And summons have since been prepared. The parties pray that as next week will not be possible, that the date this will be fixed on 20th, 21st, and 22nd of March. Order accordingly. Mr. Estapa prays aloud to file additional list of witnesses if necessary. Yes. So do you remember the date? It's 19, 20th, 21st.
Is it 20, 21, 22?
Oh, sorry, 20th, 21, 22, right?
Oblige.
Yeah, also 21, 22. Yes.
Item number 2.
May I please, Your Lordship, we received the parawise comment and for
What past comments? You come instructions you need.
instruction, your
Let us see what instructions you receive. You're going to get the file by tomorrow?
day after tomorrow, Your Lordship.
By? Ms. S. Prasai submits that instructions have been received, which he seeks to place our affidavit. Today is Wednesday, correct?
Yes.
List the matter on Monday next.
Monday.
Affidavit to be on board for the next date. Small affidavit.
Yes, Your Lordship. Much obliged.
I know.
Senior counsel is there. His presence may be recorded.
It's okay. Yes.
Yes.
Mr. K. Pauls is present on behalf of the petitioners.
Obliged.
Yes.
Obliged.
Daily list, item number 1.
Yes.
I'm seeking time, Your Lordship.
Why?
Because that my senior colleague, he's not keeping well because he have the sinus problem, so he asking.
So he's gone to the doctor or not?
I don't know, he just called me in the morning.
He's taking local medicine.
I think he went to doctor, Your Lordship.
Okay,
because
very good. Yes, as
1 and 2 is connected. Your
yes,
Lordship.
as respondent number. You appeal for respondent number.
4 and 5.
Yes, as the council respondent 4 and 5, arguing council stated to be indisposed. This is a matter of the 1 week.
Okay.
Yes.
Item number 3.
Same prayer, Your Lordship. In
Number
item
3 also.
Yes, sir.
You are appealing number 3 also.
Yes, Your Lordship. On
Mau Sao Mingi.
Mau Sao Mingi.
Same. Okay. After 1 week.
Highly obliged, Your Lordship.
Item number 4.
May it please, Your Lordship.
Yes.
Lordship, this is the matter regarding the jurisdiction of the District Council to try a suit between persons who belong to the Jaintia community. Because Your Lordship is well aware of the Kinteok or Suchang case. Now what happened here, my Lord, the respondent as plaintiff had filed a suit for recovery of possession and for...
Where the suit property situated?
Suit property is situated here in Shillong.
Then?
Suit property is situated in Shillong.
So then the suit is being tried here only?
No.
Cause of action is written here.
Section 16. No doubt the appellate court also has relied on Section 16 of the CPC. Now, Section 16 says that subject to other limitations. My lord will see Section 16. Now, Section 16 says, subject to the pecuniary or other limitations prescribed by law, suits for the recovery of immovable property with or without rent or profits, for partition of immovable property, for foreclosure, sale or redemption in the case of a mortgage, of or charge upon immovable property, for the determination of any right to or interest in immovable property, for compensation for wrong to immovable property, for recovery of movable property, shall be instituted in the court within the local limits of whose jurisdiction the property is situated.
Yes.
Now, Kintiwa Kor Sushang case, my lord, has relied on paragraph 4 of the 6th schedule. My lord, will come to paragraph 4.
Yes, you're aware. Yes. Yes.
Paragraph 4, my lord, says that the regional council for an autonomous region in respect of areas within such region, I will not read everything, and the district council for an autonomous district in respect of areas within the district, other than those which are under the authority of the regional councils, if any, within the district may constitute village councils or courts for the trial of suits and cases between parties. This is important, no? Between the parties, all of whom belong to the scheduled tribes within such areas, other than suits and cases to which the provisions of sub-para 1 or para 5 of this schedule apply, to the exclusion of any court in the state, and may appoint suitable persons to be members of such village council or presiding officers of such courts, and may also appoint such officers as may be necessary for the administration of laws under paragraph 3 of this schedule. Now, my lord, in Kintiwa Kor Sushang, the Supreme Court has laid stress on the word belong, not reside. Now, in Kintiwa Kor Sushang, my lord, the Supreme Court has said that once both the parties for the district council of any region to have jurisdiction over a suit or a case, both the parties must belong to the area, to the particular area. Well, we can understand here between a Khasi and a Jaintia, especially in view of the fact that at one time it was a united Khasi Jaintia Hills, there is no difficulty. But Your Lordship, there are around 70 plus cases which are pending in the district council, some of which have been filed by, let's say, a MIZO. There is one case which I am aware of. Now, this particular person resides in Shillong. He's bought a property somewhere in Nongthamai, and he has relied his claim under the MIZO customary law. Now, would the district council courts here have jurisdiction in such a situation?
That's a point of law. But then, Mr. Dingdo, a tentative view of the court.
Yeah. I understand, my lord.
I have a lot of reservations about the judgment. In fact, see, it is not workable. That means a person staying in Shillong entire life just because, suppose I'm a third generation Jaintia or something, then the suit will not be maintainable here.
True, my lord.
I mean,
personally, I'm not. But here's a larger issue, my lord. Now, once a person, because here there is no dispute that both the parties, they belong to the Jaintia community. No doubt the property is situated in Shillong.
Yes.
Because
That's the only submission. Because you are paying reliance on the judgment of the Supreme Court.
Yes.
Yes.
That is one point, my lord.
But then you see, to interpret it again, you say that As a result, now is held. Okay, let's go back to para 4.
Yes.
Okay, para 4 says the regional council for autonomous region in respect of areas within such region, and the district council for autonomous district in respect of areas within the district other than those which are under the regional councils, okay, if any within the district may constitute village councils or courts for the trial of suits and case between the parties, all of whom belong to scheduled tribes within such areas. So, scheduled tribes within such areas. So, what do you mean by that? Within such areas?
Now, my lord, coming to that, in Kintiwa Court, Suchang, my lord,
Other than suits and case which provisions, so and so and so and so. Right? Kintiwa has said that para 5, as a result, it's the council judgments here as such the council constituted for the purpose deciding dispute jurisdiction only respect tribals who belong to scheduled tribes within such area which such district council is constituted. Now let's see the scheduled tribe certificate of Donosh Sangchai. Where did he get a scheduled tribe certificate from?
From Giant Hills.
From Giant Hills, from the district deputy commissioner.
From yes. Now, my lord, here in Kintiwa Court, Suchang, it would have no jurisdiction where one of the parties. Now, I am stressing on this in paragraph 5 of Kintiwa Court case. It would have no jurisdiction where one of the parties belong to another area which is under the
then okay,
jurisdiction
take
of
it to the normal courts then.
That's what is my, because this will have an effect on all other cases.
So you mean to say that it amounts to that a scheduled tribe person, suppose a Jaintia who resides in Shillong,
Yes.
in matters of suits becomes a non-tribal? That it amounts to that.
It amounts to that.
I mean, you lose. That means that you lose your scheduled tribe status by belonging to the district
True,
to
man.
approach the council.
As I said, my lord, personally,
then it goes against para 4 itself, the green para 4. If para 4 was put in there to try certain tribals, and if the proposition now is that if Garo comes here
Yes.
and he files succession, he becomes non-tribal, then
that's what the Supreme Court said.
It's absurd.
And 141, my lord, what can we say?
we can distinguish. Let it go up again, and then like maybe a better pronouncement will come. Because sad to say, but it's, this is when the matters have not been put properly by the councils who appeared before Supreme Court. Is what is the exact situation? Yes.
May it please your lordship. My lord, so far as the Supreme Court judgment is concerned, it is not coming in our way.
Yes.
141 we all of us understand. So far as the law is that has been formulated there, it is formulated on the basis of the facts of that case. Now, those two judgments, this Honorable Court has already dealt it in the previous round of litigation at page 52. I just placed paras 7 and 8 so that I don't read through the
52
judgments of my Lord's judgment of this appeal. Page 52 is a judgment, but I rely on just
52 of the
appeal petition.
of the appeal.
this is an appeal.
Second appeal 1,
Okay. 52.
page 52, the judgment starts. I just rely upon page 7.
Which is this case?
This first round, this is the second round we are here. First
Okay.
round I came, second round they ventured.
Okay.
After considering these two Supreme Court judgments, my lord, this Honorable Court had said, in this backdrop, para 7, it is also expedient to examine section 16 of CPC, which speaks that suits are to be instituted where subject matter is situated, and that the same shall be instituted in the court within the local limits of whose jurisdiction the property is situated. As far as the application of the judgment of the Honorable Supreme Court, it is to be noted that the first judgment, that Kintiwa Khor Suchiang, concerns maintenance which is claimed by the wife stated to be Panar, living in Jaintia Hills, and the husband a resident of Khasi Hills, wherein the Honorable Supreme Court held that the District Council Court Khasi Hills had no jurisdiction where one of the parties belonged to another district. It was in those facts that the Supreme Court laid the judgment. Now, in the other case, my lord, the Richard Lingdo, the ratio of the judgment is that offences were triable by the District Council Court even if prosecution was by police if the dispute was between tribals. Now, here we are on a totally different fact situation. And for this, my lord, Even para 4 of the 6th schedule also, nothing is coming in our way. It's just question of how we are placing it. As this Honorable Court perhaps correctly pointed out, that, not this one. If I may just take the this district council, Jaintia Hills Autonomous District Council Act and Rules, if you may just take that. It's very
Maybe
clear.
there is a books.
Do we have the book? Do we have the second book? No.
Yes.
Yeah, my lord has it.
Yes.
United Khasi Jaintia Hills Autonomous District Council Administration of Justice Rules, 1953. So, I am relying on that powers of the court, subordinate and additional subordinate district council courts.
That 51 Act, 51 is adequate constitutes council rules. Constitutes council rules. Yeah. Yes.
53, my lord, 53 rules.
This is
Administration
this
of
is
Justice Rules.
51. Yes. What are you reading?
The powers of subordinate.
Which clause?
18. Subordinate district council court to try civil suits and criminal cases.
Which rules are you reading? Not constituted council rules. Oh, you're reading the Administration of Justice?
Yes.
Oh, okay, 53 rules. Okay.
I've
yes,
taken my friend's book, my lord, 18, my lord.
Yes.
Subordinate district council court to try civil suits and criminal cases. Now what does this say? Subject to rules 19, 20 and 21, these will not apply. A subordinate district council court shall be competent to try all civil suits not triable by a village court in which all the parties reside. And thereafter, my lord will kindly note or, where all the parties reside or hold land
Yes.
within its jurisdiction, and if any immovable property is in dispute, the said property is also situated within the same. Now, if we take this or and, it is very clear, my lord.
Yes.
And the Supreme Court judgments, my lord, even while applying the Supreme Court judgments, we still can distinguish on the facts of the case that it will not apply, and in view of this Rule 18. And so far as the argument of my learned friend is concerned, my lord, first I say that if I play, the WS is also on record. Even in the WS, they have not made a whisper. When they filed the application on which the impugned order was
Who filed the
passed,
suit?
I filed the suit.
When was the suit filed?
The suit was filed in 2016.
When was the first objection raised as to jurisdiction?
No, that was raised after 3.5 years.
After 3.5 years.
Yes.
At what stage was the suit?
Page 38. I'll just. Sorry, the suit is of 2017, and they filed the application at page 36. They filed the application in 2019.
Okay, 2 years.
And even in that application, neither in the suit they say they belong to a panar, neither in the suit they said that because they belong to the panar, therefore the suit is not maintainable here. And even in that application which they filed, which order was passed wherein I impugned in the first round of litigation at page 36. In that application also, what do they say? That they say that the plaintiff who belongs to Panar scheduled tribe community has filed the instant suit against defendants who also belong to the same tribe. Since all the parties belong to Panar, therefore the court has no jurisdiction and therefore the suit should be dismissed. Now in this case, my lord will kindly see the affidavit.
This has come up for a 711 application. This matter has come up before this court on 711 application.
No. That was the first round when it came. This Honorable Court passed the judgment. Thereafter, I went into revision because I was relegated. They said that since I came here up in revision, it did not apply. I had an appellate opportunity. That is why I was sent back. And after I was sent back, this impugned judgment.
What was the judgment of the lower appellate court?
Lower appellate court, that is at page
What are the findings?
58, relying upon that Supreme Court judgment.
No, the findings of the lower appellate court.
That is at page 58, 156. At page 20 to 155. 150. Lastly, after careful consideration of the facts of the case from all angles, I am of the view that as both parties are residing in Madanriting and Laitumkra, Shillong, respectively East Khasi Hills, and the suit property is also situated in Laitumkra, Shillong, which is very much within the jurisdiction of this District Council Court. Hence, I find and hold that the presiding officer, subordinate District Council Shillong, had the jurisdiction to try the suit under the instant appeal. Therefore, in the light of my above observations and finding, I am satisfied to allow the instant appeal, and that is how it was allowed. This provision, we also placed the Supreme Court judgment also. We also distinguished the...
So the trial court held that they had no jurisdiction.
It had jurisdiction.
It had no jurisdiction.
It had jurisdiction.
No. Trial court also.
No, trial court said it did not have jurisdiction.
Allowed the petition.
Anything else?
That is it. I am grateful. Both the appeals are in the...
File a short written submission because this is an important issue. I'd like to bring
You file bullet points. No,
Yes, bullet
I don't
points.
want an argument.
No, only bullet points.
Arguments just...
Because this is an important issue, as I said,
Okay,
there are around 70 cases pending in the District Council of
It can't be. I mean,
similar nature.
that's the observation of this court. That means you lose your scheduled tribe status if something happens in another district in Garo Hills. That is anyway. Hearing is concluded. The parties may be allowed to place bullet points on record. Stop. Same is allowed. List up to 1 week. Yes.
It may not be listed, my lord. It may be...
Has to be listed. Otherwise, sometimes if you don't file a bullet points, it's happened very often when you conclude the hearing and they keep on.
My lord has concluded the
Papa, he'll
hearing.
tell you he's an
Yes,
expert
yes.
in that,
Yes.
in taking time for bullet points.
He has been really helping. My lord has concluded the arguments otherwise. I'm grateful, my lord.
4 and 5 are same. Connected.
Item number 6.
How many times adjournment has been taken by respondent 1?
From their side, after the hearing has started, it's the first time.
For the first time you've taken.
Yes, yeah, Judge. After the hearing has started.
Okay, then we allow you. Yes, when do you want it? Next date?
Next week, my lords.
Next week?
Yes,
Okay, after 1 week.
Yes, Judge.
much alright. May I allow to file the bullet point, my lords? As far
Or
as-
no.
Item 7.
Right.
Not now.
Lordship.
Yes, Mr. Kumar.
My lord, the notice has been issued in this contempt case, my lord, and we have already taken the steps.
Yes,
To the
for
contender,
service
my
report
lord.
not complete. Officer indicates that service report is not complete regards 1, 1 and 2. Just after 2 weeks for service report. Yes. And you obtain status. Service report stop. Petitioner also permitted to obtain status of service. Yes, accordingly on so and so.
8.
Dear lord.
Meet pleasure. Also, is a contempt for disposing of the representation, my lord. Representation has been disposed of, my lord. So now contempt is, I am supplying a copy.
Yes.
We have already filed the implementation.
Pleading whom?
against the DGP, my lord. So, DGP has passed the order, my lord. So,
Where's Mr. P.T. Sangma?
This out of petition.
We can see that.
give me the file.
We received the petition on 22nd.
Petition.
Which didn't include.
Lordship will see the contempt petition, and Lordship's direction is
Page 14.
page 14,
Yes, at 4 points.
paragraph 11, my lord, page 14. With the above noted direction, this writ petition stands closed and disposed of. It is expected that the entire exercise shall be completed, preferably within a period of 6 months from the date of the order is presented before the respondent. And your lordship will see at page 15 is the order which was placed before DGP, my lord. And the order has been passed, my lord, on 27th February, disposing of the representation, my lord.
Mr. Advocate General also, appeal response has placed on record order dated
27th February, my lord.
7 February 2024, disposing of representation of the writ petitioner on its application for appointment of compassionate ground. Accordingly, nothing remains further consideration. As order been complied with, the contempt is accordingly closed and disposed of.
A copy of the order has also been furnished to the
Order been furnished to the counsel of the petitioner.
oblige me.
This case stands disposed also.
Yeah.
Nine.
Yes, Mr. Vanswell.
Your Lordship, as instructed, Your Lordship, I don't think it will be required for us to file a rejoinder, Your Lordship, in this instant affidavit that was filed on the last date, Your Lordship, because they are not disputing any of our claims, Your Lordship. It's just that
What's your claim? All certified claims?
they never dispute any claims. It's just they stated in paragraph 4, Your Lordship, that the matter is in consideration. Until date, Your Honor, the petitioner has not got any communication yet from the department.
Yes, I'm student.
Your Lordship, that's what I'm.
That means
about
you're not
to-
considering, you're just saying considering.
Your Lordship is still under consideration. That's all my instruction is. as of now.
What's the amount?
56.
56
56,500.
lakhs. Only 56. No, 5 lakhs. No, that's 56 lakhs is 5,000. Yes, Mr. Wansworth submits that no rejoinder is necessary to the affidavit filed by the respondents. What to do?
Sure, we have to wait and
Just
until they consider.
stop. He further submits that it has been stated in the affidavit that the matters under consideration by the respondents, but they have not received any intimation. Stop. This is matter for further orders of 2 weeks. MSS room to obtain instructions. Yes, on the status of the case.
Obliged,
Much
Your Lordship.
obliged. Then,
Please, Your Lordships. My lord, this is that case where, my lord, we are seeking some, my lord, investigation against a police officer who has committed certain excesses, my lord, and exceeded his jurisdiction, my lord, in the name of investigation. And today it was fixed for filing of an affidavit by that, my lord, the private respondent, and today I have received a copy, my lord.
Yes.
So then,
Just
my
been
lord-
filed just now. Just
Yes, my
the-
lord.
Yes, this
I
morning
just
it was
received in the
filed.
morning, my lord, I got it here, my lord.
So you're ready with the matter now. Yes.
My lord, basically what happens if your lordship kindly goes through the, my lord, affidavit of the superintendent of police, and, my lord, the affidavit filed today on behalf of the private respondent, my lord, the lordships will see, my lord, there are some glaring differences between them, my lord. And one of the issue that is to be taken note of is that, my lord, that SP, my lord, was nowhere there at the scene, my lord, when these offences were been committed. And, my lord, the affidavit which was filed by the SP would be, my lord, on the basis of the, my lord, instructions given to him by this private respondent, my lord.
How are we to hypothesize that?
My lord.
How are we to go there? The thing is that the suit's pending, correct?
Suits are pending thereafter, my lord. Suits are pending, that's a different matter, my lord. But then basically, my lord, here it is the allegation is that, my lord, this officer, my lord, he went there and he committed excesses, my lord. He, my lord, injured this, my lord, petitioner, and he, my lord, had, my lord, demolished, my lord, and vandalized the properties, my lord, which he was not required to do. And here in the affidavit, I have just read, my lord, gone through one line where it says, my lord, because the owner of the property was an old lady and she could not reach out to demolish that, my lord, CC cameras, she asked for my help and I went there and I broke it off. My lord, can that be a reply, my lord? Is that the duty of a police officer, my lord? Today, my lord, here, my lord, in this affidavit which has been filed, just give me 1 minute, my lord, I'll point out, my lord.
Oh, yes. It's just that nobody mentioned that the complainant, being senior citizen, requested me to help dismantle one of the CCTV cameras.
Yes,
you
that
put
is
it
my
illegally
lordship
there.
kindly turns to page number 6, my lord.
I think this is a civil dispute.
This is a civil dispute, Your Lordship, and there is
We'll
no...
hear it.
My lord.
You file rejoinder if you want.
I'll file a rejoinder, then, my lord, let the matter be fixed for admission hearing sometime, my lord. After
Yes.
2 weeks, my lord, we'll come and, my lord.
Yes, affidavit has been filed by the respondent number
5.
5
4,
today.
4,
Yes,
my lord.
4.
4.
They are all
CM's taken.
troublemakers, Your Lordship.
CM
The
taken.
petitioners.
No, that's all right, my lord. I admit that I am a troublemaker, my lord, but a
Troublemakers.
troublemaker
They are
does not
making-
entitle him
and they are
to
giving
come
an
and beat me up, my
exaggerated
lord.
version of their plight.
Yes, yes, yes.
Yes, yes, definitely. That will be satisfied, my lord.
We'll hear both matter admission hearing, yes.
My lord, there should be a limit to some submissions being made.
It's all false allegations.
That's all right.
Yes.
That's why investigation is necessary. I'm deeply all right, my lord. My lord, is a date been given, my lord?
Your court master will give you 2 weeks, yes. Yes. Who's for the petitioner? Why no affidavit?
Lordship, we've just received the instructions, my lord.
What is the instructions here?
This also pertains to some orders
School
passed by
teacher.
this. Yes, Lordship. Lordship, I'll have to file an
What is your
affidavit, my
prayer
lord.
here?
Lordship, to pay the benefit, Lordship, as per the
What benefits?
pensionary, Lordship.
Are they salaries? You file affidavit as necessary.
Lordship.
Yes, MS Enjida submits that instructions have been received and undertakes to file affidavit within 2 weeks from today. Thereafter.
My lord. Much obliged, Lordship.
Item number 12.
If it's pension or all, I don't want to delay these matters here.
It's not
Yes, pen-
pension matter, Lordship. It's for the pre-primary teachers.
What's the matter about?
This is a seizure case, my lord.
Seizure of?
Seizure of excavator.
Of?
Excavator, my lord.
Excavator. Now what happened?
My lord, on the last occasion, Lordship has directed us to file the affidavit, and the affidavit should be on board, my lord. And my lord, our prayer
For the
was,
state or for the corporation?
my lord,
You're paying for the state?
for the state, my lord. Only state is responding here, my lord. My lord, I have just received through email, my lord, the instruction. So, my lord, I will be able to file.
When was
Lordship.
the last date it came up?
My lord, it came out on the
Yes.
12th of February, my lord.
Okay, MS
But
Arcoli.
my lord, articles have already become junk.
Junk?
Because of non-maintenance of the...
How long has it been seized and
1
kept in
year,
the
1
custody?
year.
December,
1 year.
1 year?
1 year.
You've taken them now?
No release, no, it was not released.
No, but we stopped the auction, correct?
Yes, or stop the auction, but it should be released, or I will give the indemnity bond on Jimma, because it was not reported to
Let
judicial
them file
magistrate.
affidavit, file it within 2 weeks. Then we'll dispose of the whole
My lord.
matter.
I'm grateful, Lordship.
So
Yes,
interim
MS
order may
Always
continue.
is allowed 2 weeks further and file affidavit, stop. Interim order pass, it shall continue. The next date, its endeavor shall be made to dispose of the matter in the next date.
My lord, will positively file the affidavit.
Much obliged.
13.
My lord, 12 and 13 are similar matter, my lord.
14.
Yes,
May
1, 2,
please, Your
4,
Lordship.
5, 6, what happened? Already filed.
Your Lordship,
5?
respondent 5 will require more time, Your Lordship, to file.
Similar prayer, Lordship.
What's the matter about?
Lunch, Lordship.
May please, Your Lordship, I'm praying for some more time, Your Lordship. We have not
Who's
received
paying this
instructions.
case? Mr. Sen or you?
We are praying on behalf of Mr. S. Sen, Your Lordship.
Further 3 weeks time as prayer allowed. for affidavit.
Obliged, Lordship. 16.
Yes.
Lordship, this is a letter submitted before the Office of the State Respondent, informing that they are going to withdraw this instant writ petition, Lordship.
You withdrawing it?
No, Your Lordship, we need instruction from the client.
Your client hasn't contacted you.
No, Your Lordship.
Why?
Next page, Lordship.
Why you want to withdraw it?
I need to contact my client first. A big time on me.
When clients will withdraw cases, they don't want to contact the advocates anymore. You know that? For certain reasons. Yes, Mr. M. Sangma has produced a communication dated 13 February 2024, wherein a letter of the petitioner dated 24 January 2024 has undertaken to withdraw the instant petition. Stop. Next paragraph. What's your name?
Iwarji.
MS Iwarji, learned counsel for the petitioner, submits that she does not receive any instructions. And this is a matter after 1 week. Copy to communication be made over to her also.
Pleasure.
Yes.
17.
Your Lordship, I have entered appearance on behalf of the respondent 11 and 14, Lordship. Here I filed one miscase for deleting my name, my Lord. Why this challenge is made with regard to the Dadingiri subdivision, Lordship. Now, I have not participated in the interview, Lordship, as well as I am not a successful candidate in the Dadingiri subdivision, Lordship. But they have unnecessarily added me as a party respondent, Lordship. I have filed this case for deleting my name, Lordship.
What's in this case? You're aware of this, MS Mani?
We have no objection to this application.
Okay. This case number 237.
This case 30.
This case 30. There are two miscases.
Filed by the petitioner.
Okay. In this case 30/2024 in WPC number 405. This is an application for deleting the names of the applicant. Only one. Only
11 and 14, Lordship. Because
okay. The names of the applicants from the array of respondents in WPC number 405/2023. Stop. Where have you been applicants?
Lordship, that respondent number 11 and 14.
You filed two miscases.
One miscase, Lordship.
Then
same name, Lordship.
Same name.
Same name. 11 and 14.
Twice. 11 and 14.
The same person.
Same person, my Lord. Even the persons who have not qualified, they have been made party to this.
Yes. Yes, sir. Applicant. Only of the applicant. Who has been arrayed twice as respondent number 11 and 14. Stop. It is submitted by Mr. S.A. Sheikh that no relief has been claimed against the applicant respondent, and that he has been dragged unnecessarily in the proceeding. Next paragraph. The same the prayer for deletion is not objected to by MS Iwanyang, the counsel petitioner. Accordingly, the name of, that is number 11, Shri. He is Shri Rana Masud Khan. Shri Rana Masud MASHUD Khan shall be struck off from the array of parties wherein he has been shown as respondent number 11 and 14. Stop. This case accordingly stands disposed.
Writ has also become infructuous. If your lordship kindly see page 21 of the writ petition, my lord.
Writ petition? Okay. Writ petition.
Page 21, my lord.
Yes.
The impugned final select list, notice dated 11 December 23, with regard to private respondent numbers 7 to 19 and other similarly situated shortlisted both ST and unreserved candidates who has only 18 months DLED obtained from NIS, and direct the state to prepare a fresh list of qualified candidates, including writ petitioner having 2 years for interview, by excluding the name of private respondent, my lord. Interview and appointments have already been made, my lord.
Let us take instructions.
Everything.
Also, in the main case, in view the order passed in this case also, registry to make necessary corrections in deleting the cross title. Stop. Mr. A. Kumalan, Advocate General, has further submitted that the writ has since been rendered infructuous in view of the fact that the interview and selection process is already over. Stop. Amit Iwanyang, however, please without 1 week's time to obtain instructions. List thereafter.
18.
Please, Your Lordship. Your Lordship, in this case, I may be allowed to take fresh steps on respondent number 6, Your Lordship.
You already were allowed by last order. You didn't take steps.
I've been engaged to enter appearance on behalf of private respondents number 7, 8, 9, 10, 13, 14 and 15.
See, you since that time, that was on 9th, you are asked to take 5 steps, you didn't take 5 steps. So, you're appearing for whom?
About 1 to 5 state respondents. We will require some time.
And you're appearing for?
7, 8, 9, 10, 13, 14 and 15.
That means all are served.
Your Lordship, except for 6, 11, 12, nothing has been.
6, 11 and 12. So just come again, you're appearing for 1 to 5, okay.
1 to 5.
You're appearing for 7, 8, 9, 10,
13, 14 and 15.
13, 14, 15. That means only, that means 6, 11 and 12 are yet to be served. Correct?
Yes.
MSS Room House entered appearance today on behalf of respondents number 7, 8, 9, 10, the gap 13, 14 and 15. Stop. None has appeared as yet on behalf of the respondents number 11 and 12. Stop. MS S. Shalam praised that with regard to the respondent number 6. Though fresh steps were allowed to be taken, to fresh steps were to be taken, the same could not be done due to inadvertence. She prays is allowed to take fresh steps for number 6. So petitioner also to obtain status of service on the other respondents. That is 11 and 12. List up to 2 weeks for affidavits by the remaining respondents.
19.
Lordship, this matter doesn't survive anymore, as I've submitted earlier.
This court, by order dated 11th Jan, has directed that in the event we proceed with the complaint, then before the returnable date, that time has passed, we have missed the bus. We are supposed to take up that preliminary objection raised by the writ petitioner, that whether a complaint against the Darbar or against the same should first be placed before the Darbar. Now, at this point, Your Lordship, I'd like to submit that there is another allegation against respondent number 4, that something about malafide, etc., etc. Now, we taking note of that, we have the executive committee has appointed 2 other different from respondent number 4. That being the case, we are ready to dispose of the preliminary objection raised by writ petitioner within a week's time, and 2 members have been constituted. Nothing survives.
Your Lordship, I'll take instructions.
Instructions on?
Last date also same thing, Your Lordship.
Your Lordship, I'll take instructions with regard to the new committee, Your Lordship.
I have here, Your Lordship.
Yes, your instructions. We'll close it.
Yes, Your Lordship.
Lordship, let the matter come on Friday, Your Lordship.
We do not want to prolong this, Your Lordship. It is their submission that we are delaying it.
Your Lordship, it's just a matter of...
Okay, written instructions have been placed by an order. Instructions containing an order with regard to reconstitution of the members to hear the complaint against the writ petitioner has been filed for the court today. MSB of Long place the matter listed on Friday. We list on Friday.
I'll take instructions.
We'll close it on that day.
Your Lordship, highly obliged.
Item 20.
May I please, Your Lordship? May I please, Your Lordship? Your Lordship, I humbly pray 2 weeks' time, Your Lordship, to
How
file
much time?
affidavit. 2 weeks' time, Your Lordship.
Okay, 2 weeks' time as placed by MS and Rajiv. Have response allowed for affidavit.
21.
May I please, Your Lordship? You have served the notice, Your Lordship, to respondent number 4, Your Lordship.
Number? Yes, you received MSB of Karman Lang and on behalf number 4 today. Such notice and all respondents is complete. What about affidavit?
Affidavit, I'm yet to receive instruction, Your Lordship. I mean, given
Next paragraph, Mr. H. Abraham, and for 1, 2, 3, and 5, and MS for 4. Please for allowed 3 weeks' time to file affidavits. Yes, thereafter. And so
Item number 3 is connected matter, Your Lordship.
Okay. Same order.
Hearing.
Yes.
Supplementary list, item number 3.
Your Lordship, this matter has been posted as a fixed matter today. I have prepared a summary of the submission, Your Lordship. To simplify the matter, the short summary.
Other side who's there?
May I please, Your Lordship, my learned friend can start. Mr. Sengupta will be joining shortly.
Where's Sanjupta?
Sanford.
He's in office, no?
Office. He's coming.
Call him.
Mr. Shekhar.
Your list has something to say, Mr. Gupta. You've given judgments also, Mr. Kinta?
Yes, Your Lordship. There's a book, the list of citations. There are about 20 citations, but what I have brought before Your Lordship, the extracts, is just 10 numbers. They want to burden the court, Your Lordship.
Okay, start. Let's refresh while you're waiting for.
May have a look at my short summary of submission. Lordship, as on 27/9/2007, the service under which all the petitioners were appointed, back and post thereof, were advertised for selection process. I'll not burden the court by going into the annexures right now, Your Lordship. I'll just continue.
It's okay, you can burden the court, no problem.
Much obliged, Your Lordship.
Yes.
Annexure 2.
Yes.
Which is dated 27/9/2007. Which is at page 26 of the writ petition.
You see the term of appointment? 26.
Annexure 2.
Yes.
This is an application in prescribed.
26 advertisement.
This advertisement, Your Lordship.
Yes. For the post of junior divisional accountant.
Yes, Your Lordship. Junior divisional accountant under 3F of the MPSC, limitation of function rules, until regular recruitment to
Yes.
MPSC, etc. I come to the next point, Your Lordship. Upon selection, through due process, the petitioners were appointed and they joined their respective places of posting as per Annexure 3, 4, 5, and 6 and 7. That is at page 27 to 35 of the writ petition, and the list is as provided in the table.
They all joined between 2008 2009.
Yes, Your Lordship.
Mr. You ready, Mr. Sanvita?
Yes, my lord.
Very good. Yes.
A copy of the short summary and the citations are supplying to the Government Council for easy reference, Your Lordship. Now, Your Lordship, I come to the next page of my summary of submission.
How many petitions are here?
22, Your Lordship.
22. Yes.
Now, Your Lordship, as on 1st July 2016, the petitioners were allowed to cross efficiency bar and also granted increment wide office order dated 9/11/2021, which is Annexure 9, page 39 of the writ petition, Your Lordship.
Annexure 9. Annexure 1/7/2016. Not page 36.
Annexure 7. Annexure 7, page 36.
36, yes. This is 9 November 2001. 21. You, what are you referring to?
Oh. That is
you give the date, what is 1/7/2016?
1/7/2016.
Oh. Where does date 1/7/2016 come from?
Oh, yes. Yes, Your Lordship. The effective date as on 1/7/2016, that is in column serial number 1, Your Lordship.
Okay.
That's what I'm trying to
Okay, yes.
show Your Lordship. And Annexure 7, page 36. On being regularized by Finance E Department letter so and so, dated 19/2/2021, and on successful completion in service departmental examination declared by this office so and so, the following JDAs are optionally, notionally allowed to cross efficiency bar, etc. Your Lordship. Your Lordship, on 19/2/2021, the service of the petitioners formally declared to be regularized by Annexure 9 at page 39, Your Lordship.
Regularized only 21.
Yes, Your Lordship.
After we appointed 2008, 2009.
Yes, Your Lordship. That is not my fault, Your Lordship. It is in the hands of the government.
How is it possible?
That's how it is, Your Lordship, in different
So
departments.
do you mean they're pointed out 3F since 2008, 2009?
Yes, Your Lordship. The delay cannot be attributed to the writ petitioners, Your Lordship. Now, Your Lordship, I would like to draw Your Lordship's attention to page 39, Annex 9, especially the condition number 4 at page 40, Your Lordship. The 38 numbers of junior divisional accountant shall be governed by the new defined contribution pension scheme, White Finance Pension Department so dated 4/2/2021. Now, Your Lordship, when we look at these conditions number 1, 2, 3, 4, and 5, the earlier paragraph, Your Lordship, the regularization is, however, subject to the following conditions as stipulated by Personnel and AR Department letter number so-and-so dated 27 August 2017. This is the date and letter which very important for my case, Your Lordship. I will draw Your Lordship's attention to this again in my submission, Your Lordship. As
27
on
August 2007.
27 August 2007, Your Lordship had the occasion to decide this particular matter, very similar in an earlier writ petition, Your Lordship. Now, I'll come to that later, Your Lordship. Now, as on 30th August 2019, the Government of Meghalaya adopts the new pension scheme as apparent in minutes of meeting dated 12 and 16 July 2019, accorded approval and order to request all NPS subscribers to submit PAN and PRAN application at time of entering service for the first time, at time of entering service for first time for smooth effective implementation of NPS. I draw Your Lordship's attention to Annexure 11 at page 42, Your Lordship. I am directed to say that the meeting on new pension scheme performance review held on the 12th July 2019, white item number so-and-so, has accorded approval and order to request all NPS subscribers to kindly submit PPAN and PRAN application forms at the time of appointment while entering service for the first time. So, Your Lordship, just from plain reading of this Annexure 11, will notice that it is for those who are entering service for the first time when the new pension scheme came to be in operation. Now, Your Lordship, to my next line of submission. On 29/4/2011, Your Lordship, petitioners submitted several representations against the coercive action by including them under the NPS by denuting them the rights to be governed under the old pension scheme. However, there was no response from the concerned authorities. I'll not burden the court with this representation, Your Lordship. I come to the next point. Petitioners, when they joined service, were made to contribute GPF with effect from date of entry in service in terms of Rule 7 of the Meghalaya Civil Services GPF Rules 1985. While some are contributing till date and few were stopped midway, Your Lordship, by some Treasury officers, and the chart below is list of petitioners contributing to GPF. This is noticed in the rejoinder affidavit filed by the petitioners, Your Lordship. History of the summary of submission, Your Lordship. This is the list, Your Lordship. I come to item number 8 of my submission, Your Lordship. As on 27/8/2007, Office Order number so-and-so dated 19 February 2021, Annexure 9, page 3940 of writ petition, contains a reference of the letter number so-and-so dated 27 August 2007. Your Lordship, I have already read that some time back. Anyway, for the easy reference of this code, I draw your Lordship's attention to page 40 of my writ petition, which is Annexure 9 again, Your Lordship. The regularization is, however, subject to the following condition as stipulated by Personnel and AR Department letter number so-and-so, dated 27 August 2007. This is what I was referring about, Your Lordship. And this letter, Your Lordship, 27 August 2007, is Annexure 13 to my additional affidavit.
27 August 2007.
27 August 2007, Your Lordship. I've annexed it as Annexure 13 to my additional affidavit.
Rejoinder affidavit.
No, Your Lordship, it's an additional affidavit.
At page?
That is at page 5, Your Lordship.
Okay. Oh, yes.
No need to read page 5, but I'll come straight to page 7, Your Lordship.
Last paragraph.
Last paragraph, Your Lordship. However, you are also requested to ensure that regularization taken up by the appointing authority be made only in respect of the approved list enclosed below, a copy of which has been forwarded to Meghalaya Public Service Commission District Selection Committee for their information and necessary action. The regularization, when made, is subject to the following. Condition number 1, that the candidate, when regularized, would not be given weightage for their so-and-so. That is not important for me, Your Lordship. I come to condition number 2. The period of 3F appointment, ad hoc appointment of each incumbent would be taken into consideration for the purpose of leave, pay, increment, pension, etc. as per existing provision provided under FR 28 bracket A. That is what I'm trying to show Your Lordship. It is on the basis of this 2007 letter, the petitioners were regularized. I come back to my item 8 of summary of submission, Your Lordship. It contains a reference of the letter dated the 27 August 2007, Annexure 13 to additional affidavit. From the Personnel and AR Department, Governor of Meghalaya, a perusal of the said letter dated so-and-so will show that a copy of the same was marked to the Finance Department, Government of Meghalaya. Finance Department is the parent department of all these writ petitioners, Your Lordship. Vide serial number 10 thereof. And the conditions of regularization as finally adopted by the Government of Meghalaya for implementation inter alia contains the following conditions as condition number 2. I have already gone through that just now, Your Lordship. However, the impugned order dated 19/2/2021, Annexure 9 to writ petition, although speaks of condition as stipulated by letter dated 27/8/2007, conveniently omits the word pension as specified in condition 2 as quoted above, thus rendering the impugned order dated 19/2/2021, more specifically condition number 2, liable for suitable judicial interference of Your Lordship. Now, this is my submissions, Your Lordship. So far, I've given the list of dates, how it happened.
So that's it. The whole case hinges around this, that their organization, they were served at 3F, is on the basis of 27 August 2007. And this 27 August 2007, which speaks about ad hoc appointments, includes, that they'll be governed by the, they will be past service, will count towards leave, pay, increments, and pension.
Yes,
but in this impugned order, they've left out at 4,
exactly, Your Lordship.
At 3, rather, they've left out the pension part, only given you leave, pay, and increment.
Yes.
And they put you under, by clause 4, put you under the new defined pension scheme.
Yes,
and the other limo argument is that ever since you entered the service, you contributed to the GPF fund.
Yes, Your Lordship.
And so by all, for all reasons, you should be governed by the old pension scheme.
Yes, Your Lordship.
That's our
my
substance of the case.
That's my case, Your Lordship.
Yes.
And
my Lord has got it.
I've got some...
Thank you very much.
No, my lord, that is all. I have nothing more to add also, my lord.
No, let them finish.
My submission, Your Lordship, by the general circular contained in letter number personal so-and-so, dated 20th November 1978, that is at annexure 10, page 41 of the writ petition, Your Lordship. This is from the then Secretary to Government of Meghalaya, T. Kaji, to all special secretaries of all departments. Continuing, counting of the period of officiating appointment or on ad hoc appointment towards leave, increment, etc. Sir, I am directed to say that a question has been raised as to whether the period spent by a government servant during the period of officiating appointment under Regulation 3(f) of the Meghalaya Public Service Commission Limitation of Functions Regulation 1972 or on ad hoc appointment would count for the purpose of leave, increment, pension, and has received the attention of government as provided under FR 26(a) of the Assam FR and SR as adopted by Meghalaya. All duty in a post on a time scale counts for increments in that time scale. It is therefore clarified that the period of continuous officiating appointment under Regulation 3(f) or on ad hoc appointment of the government servant will also count towards leave, increment, pension on their appointment having been regularized on the recommendation of the Meghalaya Public Service Commission, etc. Your Lordship. I come back to my summary of submission, Your Lordship.
Page, it
was page 41, annexure 11.
Yes, all properly, not properly.
You did
not properly what?
Numbered. Pagination is
last time that was the same thing. We had corrected it and given it again to you. You must have done photocopy or what I don't know. Anyway.
To arrange.
You're not taking adjournment, Mr. Sangupta?
No, my lord.
Then very good. Yes.
The pagination is finding it difficult to cope with, sir.
I come to submission, Your Lordships. The
You
government
can reply
of
tomorrow, let him finish. We'll not
Yes,
hold
my
him
lord.
any longer. You can reply tomorrow, but tomorrow positively. You correct your pagination if you have difficulty. Yes. Because I don't want you to confuse the court also.
No, my lord.
With your pagination. You should tally, yes.
Now, the government of Meghalaya has clarified that it is therefore clarified that the period of continuous officiating appointment under Regulation 3(f) or on ad hoc appointment of government servant will also count towards leave, increment, pension on their appointment having been regularized on the recommendation of the Meghalaya Public Service Commission, etc. Consequently, for the purpose of consideration and grant of pension, the determinative date fixed by the government itself is the date of respective appointments of the petitioners on ad hoc basis. This policy was reiterated by the government again via letter number so-and-so dated 27 August 2007, which I've read earlier, Your Lordship, annexure 13, from the concerned department as contained in condition number 2. I will not burden the court by reading again that condition, Your Lordship. The executive state cannot now on its own impose a new date in violation and supersession of its own policy. That the different ratio emanating from various judicial pronouncements on this issue clearly holds that for the purpose of imposing a cut-off date, for the purpose of imposition of NPS, the determinative date would be the date on which the vacancy to the post would be the date on vacancy to the post in which the government servant petitioner arose, or in a given case were selected. If a government servant was selected by a legally known process of selection and appointed on a later date for the purpose of determining the applicability of the cut-off date fixed up by the government, the date of selection would be taken into account and not the date of subsequent appointment. The latest judgment on this issue was rendered by a single bench of the Guwahati High Court, Itanagar bench on 31/1/2024 in WPC number so-and-so. Following a division bench judgment of the same Honorable Court passed on 4/2/2022 in WPC number so-and-so 2021. Para 10, 12 and 13 of the judgment dated 31/1/2024 passed by the Itanagar bench is reproduced herein. For ready reference, the observation made in paragraph numbers 19 and 23 of the said judgment are extracted below. In the several judgments referred to by the petitioners of the Delhi High Court, as well as by the Uttarakhand High Court, it is seen that the consistent view of High Courts in the said matters is that where the process of recruitment have been initiated in the year 2003, merely because the appointment orders were issued subsequently in the year 2004 or later, such delay not being attributable to the appointees or the recruitees, the benefit of the old pension scheme, which was replaced by the new pension scheme from 1/1/2004, cannot be denied to such recruitees appointees who had applied for were duly scrutinized. Para 23 of the in the facts of the present case, as there is no dispute that when the advertisement was issued in the year 2003 and the selection process had commenced, the old pension scheme was in force. The judgment of Delhi High Court and the Uttarakhand High Court were rendered on facts which are similar to the facts in the present case. The petitioners had also agitated their grievances by representation dated so-and-so before the respondent authorities. In the detailed representation preferred before the authorities, the petitioners referred to the orders passed by the Uttarakhand High Court in the state of Uttarakhand versus so-and-so, and the Delhi High Court in case of so-and-so, as well as orders passed by the Central Administrative Tribunal Ernakulam bench and the Central Administrative Tribunal Jabalpur bench. The said representation, however, came to be rejected by communication dated so-and-so. The Honorable High Court, Honorable Itanagar bench at paragraph 12 further held, this court had noticed that there is no ambiguity with the factual position that the recruitment process was initiated via advertisement dated so-and-so, 19/3/2007, which would obviously mean that the vacancies which the petitioners were appointed were existing at that point of time. Even the final select list is dated 14/12/2007, which is prior to the cutoff date of 1/1/2008. And it is a matter of mere chance that the petitioners were not appointed immediately on publication of the select list, but after 1/1/2008. This court is of the unhesitant opinion that the date of appointment would not be crucial, and the crucial date is the date on which the recruitment process was initiated, which is admittedly is prior to the cutoff date. Para 13 of this judgment, Your Lordship, in view of the opposite discussion, the instant writ petition stands allowed and the impugned combination dated so-and-so is interfered with, and consequently, it is directed that the petitioners be held to be covered under the old pension scheme and benefits thereafter granted to them in accordance with law. Now, in B2, Your Lordship, the Honorable High Court, this Honorable High Court in a similar situated matter had the occasion to pass judgment and order dated 30/6/2022, passed in WC 364 of 2017, Simati, Aplin, Mary Sun and others, and at para 4, 9, 11 and 12 held. My colleague here, Your Lordship, Seema Bhattacharjee, was the counsel in that particular case, Your Lordship.
You've given the judgment? Where is the judgment?
I've given a separate list of citations, Your Lordship. You want to respond now?
Yes, Mr. Gupta, anything disturbing you?
No, sir was saying whether you would like to reply today or not. I said my contentions are very limited, so will not take much.
I'll continue, Your Lordship. At paragraph 4 of this Honourable Court's judgment, the grievances as projected in the writ petition are that, though as per letter dated 27/8/2007, which is Annexure 13 to my additional affidavit, Your Lordship, this is the same letter, Your Lordship, regularization was made with a condition that the period of trie-off appointment, ad hoc appointment of each incumbent would be taken into consideration for the purpose of leave, pay, increment, pension, etc., as per assisting, must have missed there, provided under FR 28(a). The respondent issued several letters dated so and so and so, where the petitioners were declared to be under the new defined contribution pension scheme, and further that they were to stop subscribing to the GPF. This case, Your Lordship, in this particular case, is a very similar situation, Your Lordship. They were appointed prior to 1/4/2010, way back in 1994-95, and they were regularized sometime in 2016-2017.
So you mean this judgment covers that case?
Insofar this observation of the court with regard to this 2007 letter, Your Lordship. Your Lordship may peruse this judgment of this court, which is paragraph 9 and 11, Your Lordship. Yes. I'll come to a judgment of the Honourable Apex Court, which is at B3, Your Lordship, in my summary of submission, Your Lordship. This is 2022 SEC online, so Your Lordship. The grievance of the appellant, this is a Supreme Court judgment, Your Lordship. The grievance of the appellant is that advertisement was published by the Commission on 9 November 2001 for the block year 1998-2002, pursuant to which, after selection, 51 candidates out of 53, except the appellants, were appointed by order dated 27 September 2002. And before these appointments could be made, the names of the appellants were also cleared by the Commission after due verification on 3rd September 2002. But the state government failed to include their names, while appointment of other selected candidates, including those who are in lower in order of merit, were made on 24th September 2002. And without any reasonable cause justification, their appointments were withheld for 2-3 years, and finally, they were appointed on 23rd August 2005 and 23rd April 2004, respectively, and the delay in appointments in no manner could be attributable to the appellants, and because of their late appointments, the government has denied them to avail the benefit and become a member of the scheme of 1978, which was applicable to the employees who were appointed on or before 1st April 2003. At para 11 of this decision, Your Lordship. After we have heard counsel for the parties and with their assistance peruse the material available on record, in our considered view, the premise on which the High Court has proceeded is not sustainable for the reasons that the appellants, along with other applicants, had participated in the same selection process pursuant to advertisement dated 9 September 2001, held for the post of AAP Grade 2, and verification was made by the Commission in the case of the present appellants on 3rd September 2002. In the given circumstances, when those who are lower in order of merit to the appellants were appointed by an order dated 27 September 2002, the appellants have no right of say in the matter of appointment, and no justification has been tendered by the state government, state respondent, as to why their names were withheld for 2-3 years, when their names were cleared by the Commission on 3rd September 2002 and sent to the state government, and finally appointments were made of the appellants on 23rd August 2005 and 23rd April 2004, respectively, and the delay in making appointment in the case of the present appellants in no manner could be attributable to them. In the given circumstances, when all the other candidates who had participated along with the appellants pursuant to advertisement dated 9 November 2001 on the recommendation made by the Commission were appointed on 24 September 2002, including those who are lower in order of merit, there appears to be no reason for withholding the names of the present appellant, and merely because they were appointed at a later point of time would not deprive them from claiming to become a member of the Tamil Nadu Pension Rule 1978, which is applicable to the employees who were appointed on or before 1st April 2023. The decisive ratios on this point rendered by the Honorable Apex Court are humbly summarized extract in a separate list of books.
Mr. Kenta, sorry to cut you short. That means here these two judgments. That's it. You're relying on two judgments only.
Lordship, in my item C, the decisive ratios on this point rendered by the Honorable Apex Court are humbly summarized extract, the two extracts, in a separate list of book appended separately for ready reference of your Lordship. I've already annexed, it's all flagged, your Lordship, 1, 2, 3, 4, 5, 6, 7, 10. My concluding submission, your Lordship. Hence, in view of the above, the Office Memorandum containing the new defined contribution pension scheme 2009, which had come to force from 1/4/2010 with prospective effect, by which, in bracket clause 3.1, the said scheme was made applicable to all new interns joining state government service on regular basis against sanctioned vacant posts on or after 1/4/2010, has to be applied in the case of the petitioners reckoning the date on which the vacant posts in which they were selected and appointed, and not the mechanical date of regularization. The posts have been advertised on 27 September 2007, Annexure 2, page 26, will have to be taken as the relevant date, and the respective petitioners, having been appointed on selection on 10 December 2008, 7 Jan 2009, 22nd Jan 2009, and 17 February 2009, will not be regulated by the new defined contribution pension scheme 2009. Any other view would render the new pension scheme 2009 having retrospective effect instead of its declared prospective effect, and also to be contrary to the judicial ratio laid down by the Apex Court and various other High Court as above. Consequently, the petitioners are entitled to a declaration that they are entitled to be continued under the Meghalaya Civil Services Pension Rules 1983 and the Meghalaya Civil Services General Provident Fund Rules 1985 as amended, and not under the new defined contribution pension scheme 2009. It is reiterated that even the guideline for the implementation of the new defined contribution pension scheme at para 5 provide that the Meghalaya Civil Services Pension Rules 1983, the Meghalaya Civil Services GPF Rules 1985 are amended from time to time, including the Assam Services External Pension Rules 1963 adapted by the Government of Meghalaya, will not be applicable to government employees who joined the government service on or after 1st April 2010. In other words, the existing scheme of pension, gratuity, and general provident fund would cease for new entrants to the state government. This is the new pension scheme 2009, Your Lordship. This is what it has been provided. I have not quoted outside the scheme, Your Lordship. From the illustration to the guideline, no deduction will be made towards GPF contribution from government employees joining the services on or after 1/4/2010. As GPF scheme is not applicable to all new interns from the aforesaid date. That's my short and substance of my submission. The prayer made in the writ petition are also liable to be graciously granted. Now at item E of my submission, Your Lordship, for easy reference of Your Lordship, the relevant provisions of the Act and rules are reproduced here and below. I have quoted the exact, Your Lordship. Now, so far, Meghalaya Account Services Rule 1993, that I'll not waste the time with the court. The writ petitioners they fall under this Meghalaya Account Services Rule 1993, Your Lordship, not outside. They were appointed to post
96. Okay.
Now, Meghalaya Civil Services Pension Rules 1983, Your Lordship. Rule 2, application, bracket 1. Save as otherwise provided in this rule. These rules shall apply to every government servant appointed to civil services and posts in connection with the affairs of the state of Meghalaya and who are born on establishment not declared as non-pensionable. It is for this reason that I have brought in that Meghalaya Account Services Rule 1993, Your Lordship. Now, Rule 3 of the 1983 rules, qualifying service means service rendered while on duty or otherwise, which shall be taken into account for the purpose of pensions, gratuities admissible under these rules. Rule 3Q, retirement benefit, includes pensions or service gratuity and death cum retirement gratuity where admissible. What is qualifying service, Your Lordship? In Rule 10, commencement of qualifying service. Subject to provision of this rule, qualifying service of a government servant shall commence from the date he takes charge to the post which is first appointed, either substantively or in an officiating or temporary capacity, provided that officiating or temporary service is followed without interruption by substantive appointment in the same or another service or post, which covers my case, Your Lordship. Now, the defined contribution pension scheme 2009. By resolution dated 17 September 2009, the government of Meghalaya introduced a new pension scheme which will come into effect from 1st April 2010 and is applicable to all new interns to the state government service joining on or after 1st April 2010. Apart from other features of the scheme, the most striking feature is that the existing provisions under defined benefit pension and GPF would not be applicable to new government employees joining government service on or after 1st April 2010. Now, guideline for implementation of the new defined contribution pension scheme. The most prominent feature of the guideline is that the scheme shall be applicable to all new interns joining the state government service on regular basis against sanctioned posts on or after 1st April 2010. It shall also be applicable to all government employees whose services will be regularized against regular posts on or after 1/4/2010 with the benefit of prospective date. The other highlight of the guideline is that it is mandatory for all such new employees mentioned above who are recruited on or after 1st April 2010 and become members of the new pension scheme. The guideline also stipulated that the Meghalaya Civil Services Pension Rule 1983, the Meghalaya Civil Services General Provident Fund Rule 1985 as amended from time to time, including the Assam Services etc. Rule 1963 adopted by the government of Meghalaya, will not be applicable to government employees who join state government service on or after 1st April 2010. In other words, the existing scheme of pension, gratuity and general provident fund would cease for new entrants to the state government. From the illustration to the guideline, it is also provided no deduction will be made towards GPF contribution from government employees joining the service on or after 1/4/2010, as GPF scheme is not applicable to all new entrants. Lordship, the
yes,
the citations is in a separate list, Your Lordship. This is for the reference of this order code. I've given the extracts. I'll not take the time of this code at this moment. Lordship, is provide.
You get that original judgment, and then that
direct recruit, Your Lordship, 1992.
Well, judgment of this apply very soon is 2019, not 22. You give it in your list of judgments at seal number 2. It's not 3622. It's you see from the copy.
It's 36/2022.
Judgment, no. 39,019.
Yeah, I mistake it with something else, Your Lordship. It's stand corrected, Your Lordship. It is 13/9/2019.
Yes. The judgment authored by me, I remember.
Lordship, I don't want to burden the court anymore.
Let him reply. Reply now, tomorrow.
My Lord, now itself.
Now
because
itself. Now what did you say? How justify that? The only point of justify is how do you create a distinction between the 2007 notification and your
because the
notification
scheme provides
relying on 2007 and making a distinction with regard to with denial of pension benefits.
My Lord, my Lord, after coming of the new defence pension scheme, my Lord, it has been already decided by the government that it provides that only the new entrants and those who will be regularized subsequently will fall under the new pension scheme. This has been provided in the scheme, in the arrangement of the scheme of the documents itself of the new pension scheme. This is at point 3.1, my Lord. So it is a public document, my Lord.
Where's the new pension scheme?
The new pension scheme, my Lord.
It's the same thing that I've quoted, Your Lordship.
Where's the affidavit?
In page number 13, my Lord, of my counter affidavit. Yes, my Lord. Point number 3.1, my Lord. According to this, the government has acted.
1 second.
And this.
Yeah, and so number 2.
Yes, my Lord. That's point number 2. Page number 13, my Lord.
The scheme shall apply to all new entrants joining state government service on regular basis against sanctioned vacant posts. It shall be applicable to all government employees who will be regularized against regular posts on out with effect or prospective date. So, how do you say then? How do you?
So, my Lord, whoever is regularized after 2010, my Lord, according to the scheme of this document.
Authorization.
So, my Lord,
2007.
according to this, the government has come down with the decision that they will be covered under the new pension scheme. So, the scheme itself provided the provision for all the government employees, which were made aware of to all the government employees.
These are just guidelines, they're not statutory rules. But then the order of regularization said followed 2007.
That is where, my Lord,
what value do the guidelines have?
My Lord, government actions are guided by.
You argue on law. What is the how much weightage can you give to guidelines? This is guidelines.
My Lord, the guidelines is the.
You have the authority to show that in such cases with a scheme of guidelines that has to be scrupulously followed.
No, I don't have any authority.
Even that in the order itself, we already said that as pursuant to that's it, August 2007. So are you making a distinction there?
No, my Lord.
Then
I don't have any authority on that, my Lord.
Where we said that this guideline is mandatory.
My Lord, this is what been implemented by the state government after the coming of the scheme, my Lord. So, to support this action, my Lord, as of now, I don't have any authority on this, my Lord. So, I will rely completely on the guidelines.
What do you mean by relying on the guidelines? You can't argue the case also. This is the way we defend the government. Certain action the government has been questioned by the petitioners, correct?
Correct, my Lord.
And then you take recourse to guidelines. Now, what's the law that backs up? What is the status of guidelines? Especially in this case. That means to say, Mr. Sengupta, law follows the facts, right? Right or wrong?
Right.
The facts are given to you by your clients. The law is your input. Remember that.
Yes, my Lord.
Then?
But, my Lord, in this...
But you just wash off your hands that this guideline is there. I don't care.
My Lord,
you give
in similar kind of cases, my Lord, I could not get a single citation where...
No, what are the status of guidelines, these guidelines? In law, what is the status of guidelines?
My Lord, all the actions...
Statutory
guidelines are the guidelines which has to be followed by all the actions has to be covered by that.
Either before a court, we can just make any kind of submission and, throw the file at the court and say decide anything. You have responsibility towards your clients also.
Correct, my lord.
Then?
But sometimes the occasion is very difficult, my lord.
You don't get occasion to argue your case or no?
Because
see, it's a. Where is that impugn order, Mr. Kinta?
That's 9.
You come to Section 9. Let the court help you. Yes, come to Section 9. Now, how do you reconcile this Section 9? You have to assist the court.
My lord.
If you want good judgments, you have to assist the court effectively also. Section 9, that page?
Page 40, Your Lordship.
Page 40. How do you reconcile this?
Page 40.
How do you come to page 40? How do you reconcile these two clauses which you have given in this regularization order itself? First, you say regularization is subject to the following conditions as stipulated by personnel at department number so-and-so date 27 August 2007. Okay? 2007 says that for the purposes of calculating the seniority and so on and so forth, that means all the other things there, it goes towards leave, pay, increment and pension. Correct? As per existing provision provided under FR 28A.
Yes, ma'am.
Now, by the next clause 4 is just without any justification. It says 38 numbers of general so shall be governed by new defined contribution pension scheme. Now, while regularizing these people, have you taken into account the fact that they've been contributing to GPF? Or what's the legitimate expectation? So how do you reconcile this? You have to answer this. How do you reconcile and say that the guidelines are mandatory? Notwithstanding anything else that it overreaches all the other, even the regulation order. That means this is
the regulation order has come subsequently after 2010. Henceforth, my lord, they are being directed to be covered.
Then why did you put this clause there?
My lord, this is the decision of the government, my lord, to implement the new pension scheme.
And why do you put this? Why do you
there
put
will
this?
Be always there will
why
be,
do you put
while
this
trying to implement while trying
to
to
govern? It says it'll be is subject to the following conditions. The regarding subject following conditions as stipulated by personnel in our department, date 27 August 2007, and that 2007 clearly says where the 2007.
My lord, while trying to implement any scheme, my lord, this will sometimes benefit some and sometimes it will deprive some, my lord. That is where, my lord, my lord, the larger benefit has to be seen, my lord. The government has come. Larger benefit is that, my lord.
Can you take away something which they have acquired some kind of right?
It is not the vested right, my lord. That is why they had the vested right. Government would have definitely not.
Do one thing. You meet the authorities that have been placed by the petitioner.
My lord, that is not in respect of their regularization, which came subsequently, my lord. Their conditions, which the case laws which they have cited, my lord, they are pertaining to appointment, my lord. If their appointments were to be done on this date or on the date which they are supposed to follow.
Won't the analogy follow? Won't pension be a part of the package that comes for any employee? For consideration length of service, for consideration of payment of pension or increments.
That is where, my lord.
That is where what?
My lord, the scheme provides so, my lord. So we have to act.
Go over the scheme provides so.
We have no choice but to follow the scheme, my lord.
So you're surrendering the case. It means.
I'll
record out there that you admit that that the.
No, I'm not admitting. We are following the scheme, my lord. We are following the scheme. We have no. I am not in a position to admit.
Has no arguments to make, and has just placed relied on the scheme only, and has not clarified to the court whether they're mandatory and what are the nature of the guidelines.
No, it is mandatory, my lord. It is mandatory.
Then show the law is mandatory. Show instances where it's been made mandatory. Show other cases where this has been implemented in similar situations.
Of course, we have not brought this on record, my lord, but it is, once the guideline has been placed, my lord, it will be bound to be covered by all the new entrants. Yes, my lord. No new entrants will be allowed to be covered under the old pension scheme, my lord.
That is why I said reconcile. How do you reconcile this appointment, their regularization
order?
And
whoever will be joining the service, they will know the service conditions.
Don't make this argument.
My lord.
You know what old CRC used to say, like a broken record going on and on, same thing.
I have nothing.
Argue on law.
I have
What is this? You say it's mandatory.
Yes, my lord.
That's all. Okay, we'll reserve judgment then.
Can I say something on that?
You don't even prepare matters. What can we do? A court, the quality of judgments rendered by a court depends on assistance that receives. That's all.
Lordship, right, Lordship.
Item number 4.
Yes.
My lord, first of all, I'd like to apologize for yesterday, my lord. There was some network error.
Yes.
I could not. My lord, this matter pertains to where my earned leave, even though I was working during the COVID time, and during my period has been taken as earned leave, and I gave an application even after my application has been rejected, where the HOD was assigning me duties, and I was doing the duties online, my lord, and that is on record, my lord, everything of it. So the last time, my lord, had directed the NEHU to get in. My lord, the period I went on leave just before 3 days of the COVID started. After I went to Calcutta, my lord, I basically belong to Calcutta. The moment I reached Calcutta, the COVID outbreak had started.
No, was the lockdown? My lord, when did you go to Calcutta?
My lord, I went to Calcutta on 20th March, my lord.
When was the national lockdown?
My lord, 23rd March, my lord.
Okay, so fair enough.
Yes, and from there, my lord, I rejoined back on duty on December, and in between, my lord, all the classes that were assigned to me, that were done by me through online, and for that my record is also there.
Oh, listen,
my lord, I would like to.
What is the amount of the days of absence? The arrestation.
My lord, 18 days. My lord, Annexure 19. Annexure 19, page 96, my lord.
Yes.
May I read, my lord? Annexure 96 and Annexure 19, page 96. In pursuance of the Executive Council resolution so and so, as per your leave record, you are having only 72 earned leaves and 218 half pay leave at your credit. You are required to apply for leave as mentioned below in prescribed application to be routine through the head of the department at the earliest for further necessary action on the matter. Earn leave for 18 days for the period 28/5/2020 to 14/6/2020, for 54 days for the period of 11/7/2020 to 2/9/2020, and half pay leave for 99 days for the period of 3/9 to 10/12/2020. So, my lord, I can show on record, even it's on record, I can show that on the dates they have given, I have been working as a professor and I have been carrying out assignment, and the HOD has been giving me assigned duties. And the situation was such, my lord, there was a pandemic going on, and there was travel restrictions and everything. And in fact, my lord, even the Meghalaya government and even the central government's notifications have been annexed by me in my reply, where it has been categorically stated that online coaching, online classes should be given priority. And that had been done, my lord. So how can, my lord, once I'm working there and I have been doing classes online, they have asked me to take this.
Mr. Sharma, so this is 30th June 2021. What happened after this?
Yes,
when he said that you are having studies and so you've got to apply for leave as mentioned below. So did you apply?
Yes. Yes, my lord, I had to apply because I did not have any choice. Because, my lord,
what happened after that?
My lord, an order was passed. That was on Annexure 21, page 99, my lord.
Page 99.
This was the order passed. Sanction of the Pro Vice Chancellor NEHU, Shillong, is hereby conveyed to the grant of leave of Professor Bilakishan, Department of Zoology, NEHU, Shillong, as shown below. Certified that Professor would have continued to hold the same post, but for proceeding of leave of the aforesaid period.
So why do you file his application then? Yes.
No, my lord, because the situation was such, my lord, may see page 96, my lord, once.
Yes.
My lord, this is a council resolved, my lord. Council resolved that establishment 2 section will examine her leave application as per existing rules and withhold her salary from the month of December 2020 onwards till finalization of entitlement.
Where are you reading from?
My lord, page 95, my lord. page 95.
Okay.
The council resolved.
Yes. Okay. Yes.
The council resolved that establishment 2 section will examine her leave application per existing rule and withhold her salary from the month of December 2020 onwards. So they basically threatened me, my lord, that if you do not do this, we will hold your salary, and they did hold my salary, my lord. So I had no other option, and my lord,
what does it say?
My lord, the council resolved, my lord, may I?
Annexure 18. Yes, prolonged absence, I think so. You read this. The council's apprised, read from there.
Council was apprised that Professor Bela Kishan, Department of Zoology, Nehu was out of station on casual leave from 23rd to 25th March after taking sanctioned leave permission from March 2020 to 25th March 2020 to visit her hometown, Kolkata. However, the head of Department Zoology, Nehu, filed letter 16/9/2020 informed that is out of station. I apologize, my lord. On station leave from 20th to 25th March 2020 till 16th September 2020. And in between, Professor Kishan has sent some emails letter for grant of permission to work from home in view of the COVID-19 pandemic lockdown or other reasons, and that the email letters have been forwarded to a register for the necessary action. Now the department has started examination related work besides other administrative responsibility to faculty members, and therefore Professor B. Kishan presence is required in the department and needful to be done at the earliest. The matter of absence and negligence of duty was communicated to Professor Bela Kishan on 5th October 2020, informing that the authority has viewed very seriously of not being present, reported in the department, and she should report the department immediately, latest by 12th October 2020, and submit a charge report through proper channel. She was further informed that a prolonged absence from department till the date of resumption of duties will be settled strictly as per provision of the rule only after joining the department. In response to the letter, Professor Bela Kishan has furnished a reply on October 9, 2020 that due to extraordinary situation of spread of COVID-19 pandemic, she was compelled to stay back in Kolkata, carrying out her duties online from Kolkata, and that she finished and assigned syllabus of the MSc and PhD coursework online, have also conducted internal assessment test and set the question paper of the internal test and semester examination while working from home at Kolkata. Now, due to serious sickness of her aged mother, she is requesting to allow her stay in Kolkata and extend her physical reporting in the department till such time the doctor advised that the mother is medically fit. Due to COVID-19 pandemic, she is requesting to allow her to take her teaching, learning activities online from her home, or allow her to take leave as permission under Nehu rules. The council was further apprised that Professor has reported to her duty on 11/12/2020 and submitted the charge report to the establishment section. The council deliberated on the matter. Thereafter, my lord, the council resolved that the establishment too will examine her leave application as per existing rules and withholding her salary from the month of December 2020 onwards till finalization of her entitlement deduction of allowances during her leave absence from the head.
One thing, question, Mr. Sen. Were the other professors also similarly situated? Some of them happened to them only.
He has just read one resolution. This resolution was preceded by another resolution to take care of, my lord, many teachers who, number one, opt-in leave. They never reported. Of course, my lord, what happened? COVID. We could not have insisted them. COVID lockdown was there. Then some of the teachers, what they did, they sought permission to leave the station. They went out station. That also we are very liberal. I'll take my lord to that resolution.
Yes, continue. So,
that resolution, my lord, need to go into.
Yes. My lord, thereafter, I submitted an appeal. And in my appeal, my lord, that is that page 100, my lord. Annexure 22. Where I wrote to the Joint Register Establishment 2 an appeal for condonation of the leave for the period 28th May to 14 June 2020
page
and 11...
Page 122.
No, man. Annexure 22, page 100, my lord. Okay. Annexure 22.
Yes.
From Bela Kishan to the Joint Register, my lord, that your letter number so-and-so on the subject of regularization of leave, an appeal for the condonation of the leave for the period of 28th May to 14 June 2020 and 11 July to 12 December 2020. My lord, this is the core period, my lord, where the COVID had struck, my lord. And it was this period wherein I have been working. And for that, my lord, I can show that there was an email exchanges between the HOD. My lord, page 142 and 143, my lord.
142,
my lord.
Yes.
My lord, this was a letter from myself to the HOD, to the head of the Department of Zoology, Nehu Shillong. I, Bela Kishan, Department of Jail, Nehu is presently out of station in Kolkata. I left Shillong headquarters for Kolkata on a personal emergency on March 28, 2020 by taking casual leave for 3 days. I stationed leave from March 20 to 25. However, as a nationwide lockdown was imposed upon March 25, 20 in an attempt to slow the spread of coronavirus, I couldn't reach Shillong back. The same was communicated to you through email dated March 5th, 25th, April 14, May 4th, and May 17, 2020. Further, please note at the third paragraph, as per Nehu guidelines, I am working from home at Kolkata. As informed you in my email dated May 26, 2020, I have already completed my entire assigned syllabus for the following papers online as following using Google Classroom non-live. Then further, I am also utilizing this period to read scientific lecture and writing manuscript paper. Now I am in the last stage of writing one manuscript, which I will submit to a suitable journal shortly. Further, I have already published one paper. This was the reply to which the HOD stated at page 143.
Yes.
Respected Madam, please kindly refer to the below letter from register. Kindly provide the information. Then again at 145. To the 145, my lord. My regular report for the week of June 10, 2020 in the prescribed format. Then on page 155, my lord.
Yes, what is this?
I know these are all the inputs of the annual reports that were assigned to me, and the same was replied back to the
reports in the normal course of business that you have to, suppose you take physical classes also, you have to file.
Yes, no, I know this was basically assigned to us
what see, Mr. Sharma, please
yes,
listen. Now these reports, as requested, please attach file in PDF format and MS Word regarding input submission for a compile. What is the annual report of 1920? It is your personal report or the report you
No, my lord. With regard to the classes, my lord. Even I have classes, my lord. There was
just listen. Now this annual report on 1920. Even in a normal course, that means when physical classes are taken, this is prepared also. Or what is this?
Yes, my lord.
Okay.
It is prepared then also, my lord.
Okay.
And my lord.
Yes.
My lord, thereafter, my lord, this is on 164. 163, my lord. I'm so sorry, 163. Page number 163. 163, my lord. This is on 13th August 2020 now. We are in. So this is by HOD that's been written to me, my lord. The dear Professor Bela Kishan, you can send this question paper end semester examination of insects physiology special paper to HOD through email. Please send question paper from your nehu.ac.in email account for conducting the continuous internal assessment test through online mode. UGC guidelines circular in this regard has been sent to you previously by HOD for information and necessary action. Then I replied to the letter, I am in charge of insect psychology special paper. May I thus request you to let me know whether I can send a question paper to you through email so and so. Further, may I request you, what about the practical classes couldn't be held through online mode? so then thereafter, I had conducted the internal test. I have informed to the respective authorities, and similarly, my lord, there was a reply to those letter that is at page 165, 166. So that
Okay, this is some
where
substance. So, okay, Mr. Sharma, some substance to your case that your leave was not unauthorized, and then that there was that you're conducting classes, so amounts to regular,
yes, my lord.
irregular attendance.
Yes. Yes, my lord. Because my lord may at page number 218, my lord, 218. The simple glass on 218 that I apologize, my lord.
1 second. 1 second. नहीं आज ये पूछो तो मीटिंग 1 बजे है ना क्या 180
218 my lord 218 218
yes. What is this?
These are the student feedback, my lord, for teacher Professor Bela Kishan, for paper Animal Psychology, 1110, my lord, 220, 2020, page number 220, against student feedback.
Student feedback my lord, is the students have to sign it, or what do you call it?
My lord, this was sent to us, my lord. This was sent to us. What was the student feedback with regard to the report that I submitted? And what was the report? So they just shared the report with us. Question paper.
What is he doing?
My lord, so these are the students' report, my lord, where my lord may see that the students have given a feedback which was shared with us, and it respectfully shows that I have been conducting classes and there was no dispute about it, my lord.
Yes.
And this has my report that all the updated information that I have given is being shared through their own online service, that is Yukti. There was a platform that was created by Nehu, and for that, my lord may see page 226. At 226, please find attached file regarding the data required for Yukti. Please note that since this was thereafter when my mother was, because I was in a COVID situation, my mother was diagnosed with COVID and all. So I was taking leave for that, but still I was conducting my classes and all the assigned duties that were assigned to me. I was doing it. So there was never a question that I was not physically present because of the pandemic situation. It was not that I was absent from duty, my lord, because the situation was such that I couldn't travel. So, in fact, my lord, in the affidavit in reply, which I have given, my lord, may kindly check once, my lord. Affidavit in reply.
So can you cut down your submissions? What that means is that's the only cases that you've been taking online classes, and so where's the impugn letter or impugn order?
My lord, the impugn order is page 99, my lord.
99?
Yes, my lord. Page 99 is the impugn order. Writ petition, my lord. And of my affidavit reply, I just wanted to show one thing, my lord.
99 is Annexure 21. Certified that Professor Bela Kishan would have continued to hold the same post.
Yeah, this is the impugn order, my lord.
This is a impugned order.
Yes, my lord. Because, my lord, because of this order, because this is an impugned order, and even that my appeal been rejected, that is also is there, my lord.
No, I don't understand this letter. Order 12 July 2021.
Yes, my lord.
Where have you written in your
Annexure 23 and Annexure 12.
In your course title, you've impugned letter 15/12/21.
Yes, my lord. Annexure 23, my lord.
Then this one is 12 July 21. It's not, you haven't impugned it.
1 minute. My lord, because my leave application was rejected.
Very confused.
That is why there was an order. No, my lord. Annexure 21 was the order where my earned leave was, they given an order of earned leave. I given a leave application and that was rejected on page Annexure 23. That appeal for condonation of the leave. I am directed to at page 248, Annexure 23. Page 248, Annexure 23, my lord.
Okay.
5/12/2021 that your appeal for condonation of leave dated was not considered, hence rejected. My appeal that I had given that you please condone my leave because at that time I was working and I had given the entire set of working papers, that was been rejected by 15/12/2021, and that is why my impugned order, my lord. And 5/10/2021, 5/10/2020 is Annexure 12, which I had showed you, my lord, that the order by which they have taken an earned leave. So, my lord, I'll just like to show, my lord, the affidavit in reply of mine, my lord. Page 76, my lord.
Page after reply.
Yes, my lord. Affidavit page 76, my lord. Annexure 12.
76.
Yes, my lord. This is a UGC guidelines for reopening of university and colleges post lockdown due to COVID-19 pandemic. This was 5th November 2020, my lord. And the guidelines was issued on November 2020.
What does it say?
My lord, it says that at page 81, reopening of campuses, issue and challenges.
So what impact does this guidelines have on your continuation of
Because, my lord, because UGC guidelines were very much clear that reopening of colleges and post-lockdown, that what was the time, they framed it in November 2020. And after November 2020, they have set guidelines that when the teachers can come offline, like do physical classes, that was the guidelines was issued. And this was there in entire India, where before that, the online classes was promoted, or online classes were asked to be done by the teachers because there was a COVID lockdown. So NEHU, on the other hand, what is it doing? They are taking my entire period of working during the COVID pandemic period as earned leave when I was working. Whereas the UGC guidelines itself had come in on November 2020
where's the
with regard to
guideline? Let's see. Where does it say?
Yes, my lord, at page 75, my lord.
Yes. Of the affidavit.
May I read, my lord? Yes, affidavit in reply, my lord. Of my affidavit in reply. Page 75 of my affidavit in reply.
Yes. Night curfew.
UGC guidelines for reopening of university, college post lockdown due to COVID-19 pandemic. And Annexure 12, page 75. Affidavit in reply, my lord.
Your pagination is wrong. 77. Yes.
76 it will be. 76.
Yes. Okay. No, here in your
yes.
In this affidavit 79. Yes. 78. Yes. Yes.
UGC guidelines for UGC guidelines for reopening and universities and colleges post-lockdown due to COVID-19, 5th November 2020, my lord. Respected Madam Sir, universities and other across the country have been closed since 16 March 2020 when the government of India announced a countrywide lockdown. A University Grant Commission issued guidelines on examination and academic calendar for the universities in view of COVID-19, pandemic and subsequent lockdown on 29th April 2020 and then on 6th July 2020. The university and colleges have put in their best effort to continue the academic program and complete. My lord, page 75, annexure 12, 76, annexure 12. Affidavit in reply, my lord. My affidavit in reply.
Oh yes, 76, annexure 12. Okay, yes. Yes, okay.
UGC guidelines for reopening the university and colleges post-lockdown during COVID-19 pandemic, 5th November 2020, my lord.
Yes, read it.
Yes, the new academic session, second paragraph, is going on and the university and colleges need to customize plan as per the local conditions where they are located to deal with any individuality arising due to COVID-19 before resuming the activities on campuses. The top priority while opening the institution should be the safety, health and well-being of the students, teachers and staff. In view of this, UGC has framed guidelines for reopening of the university and college post-lockdown due to COVID-19 pandemic, which provides in detail in measure will be taken before reopening of campuses, my lord. These guidelines have also been vetted by the Ministry of Health and approved by the Ministry of Home Affairs and the Ministry of Education. The guidelines will be adopted by the institution as per local conditions and directive of government authorities. You are requested to adopt these guidelines and take necessary steps to implement them accordingly. Further, the university colleges have to ensure that it is prepared in all respects to carry out the academic activities following necessary advice, guidelines, direction issued by the central state government, MOE or UGC from time to time to prevent the spread of COVID-19. Now these guidelines are, my lord, are at page annexure 1. Annexure 1 of my affidavit in reply, my lord. The guidelines of phase reopening unlock 1 of my affidavit in reply, my lord. Page 21. Page 21.
Let us hear the Nehu what I have to say. Yes, so your case is based only on this, like the school, college, and so on, so opening after consultation, blah, anyway. Yes.
Please, Your Lordship. Lordship will kindly take up, my lord, my affidavit by the university. I have all the relevant pages, my lord, for the sake of convenience, Your Lordship. I have annexed in my affidavit, starting from the leave sought by her. My affidavit by the university. This is respondent number 1 to 4.
Don't worry, you allowed to reply.
No, she has got it. My affidavit.
Yes.
Now, my lord, here are two things. The first letter seeking leave, I have annexure 1, page 14, my lord. Her letter. I would like to request you to grant me casual leave on March 23rd to 25th, 2020 for some personal emergency at my home at Calcutta. I further request you to allow me to leave station from March 20 to 25, 2020 for visit to. Now, Lordship will see, my lord, this happened, my lord, admittedly just before the notice for lockdown. Lockdown notice was issued on 23rd March. It's true, my lord. Before that, she had applied. She had applied 2 things, my lord, casually for 3 days, and also permission to leave the station. That's very important. You just cannot leave the station without permissions. So this was granted. This was granted, my lord. But unfortunately, when she was in Calcutta, this COVID lockdown, my lord, started. Now, my lord, if Your Lordship come to the next page, we have also extended, my lord. This is the notification by the 23rd March. In pursuance to the instruction received from the UGC number such and such, preventive measure to achieve social distancing, permission to the teaching, non-teaching staff shall work from home. Notified that faculty members, research, teaching staff should be permitted and advised to work from home. So, my lord, this was allowed, my lord. So, next notification also, my lord, we have extended it further. The time was further extended, Your Lordships. Now, my lord, will come to 17. 17, Your Lordship. Now, this is letter dated 4th May 2020. Now, my lord, some kind of relaxation was there. Now, all these guidelines my learned friend has referred to, my lord, from the UGC. These were number 1 guidelines. Secondly, all these guidelines say a decision will be taken
local level.
into consideration the local conditions. This local condition was not same across the country. So, my lord, considering the situation, my lord, and lifting of partial restriction, my lord, we have taken a decision that at least the 50% of the employees, my lord, they would attend and do their works, though the teaching will continue online. Now, my lord, if I can take your lordship to the next page, page 18. Now, what happened in the meantime, my lord? She continued, my lord, remained in Calcutta. She never even tried, my lord, to extend her permission for station leave. Without station leave, she continued. Now, my lord, this is the first time, my lord, it was brought to our notice. There is a letter dated 16 September 2020 from the head of the department. To the register, my lord, Professor Belakishan out of station on CL such and station leave 2020 March, copies of email of Professor BP forwarded to the register. Dear sir, with reference to the subject cited above, I wish to inform you that Professor B. Keshan is out of station on casual leave 23rd to 25th March 2020 and station leave 20 to 25 March 2020 till this date. In between, Professor Keshan has sent some email letters for grant of permission to work from home in view of the COVID-19 pandemic lockdown or other reasons. The email letters have been forwarded by me to the Register AR for necessary action. Now, department has started examination-related work besides other administrative responsibilities to faculty members, and therefore, Professor B. Keshan presence is required in the department. I shall be grateful if you can do the needful in this regards. Now, my lord, here I want to point out, your lordship, what my learned friend is saying online. It is all right, but teachers, they have involvement in administrative works also, your lordships. So she was totally absent, and lordship will take note, my lord. She never made any endeavor, my lord, to extend her station leave permissions. Well, after this, what we did, your my lord? Next page, your lordship. Well, sorry, not next. Page 20, my lord. Based on this letter, my lord, we wrote to the writ petitioner, that is dated 5th October 2020. Madam, I am directed to inform you that the authority has viewed your case very seriously for not being present reported in the department. In this connection, it is hereby directed that you should report to the department immediately, latest by 12th October 2020, and submit your charge report through proper channel accordingly. Your prolonged absence from the department till date of resumption of the duties will be settled strictly as per the provision of these rules only after joining the department. The issue with the approval of the Vice Chancellor. So she was appraised. She was unauthorizedly absent, my lord, only taking online classes, managing the link. That is not enough. There was partial restrictions were partly lifted. Attendance were required. Her involvement in the administrative works was required. She was absent, my lord. And ultimately we received this letter. Thereafter, my lord, what happened? Generally, there were other teachers also. What your lordship asked me, other teachers also left the station, my lord, without any permission. Now, my lord, in this situation, my lord, this was brought to the notice of the Executive Council. Now, my lord, we will appreciate, my lord, one thing. What is the executive? The highest decision-making authority of the university. Now, my lord, Executive Council took note of this situation. Generally, what happened? Now, my lord, Executive Council in its meeting held on, my lord, 15th October 2020, passed a resolution. That is, my lord, at page 21, Annexure 7, my lord. Annexure 7. 15th October 2020.
Tell him to mute him first. Why is opening the pages?
Lordship has got it, my lord.
Yes, yes.
My lord, that is the resolution 21. Dated, my lord, the minutes of 175th meeting of the Executive Council dated 15th October 2020. Well, I'll just read the resolution, the next page, 2022. 6.7, others 1. The Council was apprised that so many faculty members, staff, others are in the habit of leaving station without sanction of proper leave and remain absent from duty for a long time which affects the normal functioning of the department academic activities. From the outstation hometown, the faculty member staff informed that they are on work from home in view of the COVID-19 pandemic. The Council deliberated on the matter. The Council resolved that no staff faculty member should leave station without sanction or proper leave, and that action as per the rule will be taken for such unauthorized leave absence from duty. The Council further resolved that necessary concession may be given only for the period of complete lockdown, that is from the date lockdown was announced by the Government of India till the period railways, airlines, travel facilities being operational functional. Thereafter, anyone who was out of station has to apply for proper leave, failing which necessary action need to be taken. The Council also resolved to list out the name of faculty members, officers, staff from the records by concerned section who are in out of station now and take necessary action as per the rules. The Council also resolved that a circular in this regards will be issued to all departments from the administration. The Council resolved that work from home is to remain in station and not out of the station and has to be examined case to case basis. The Council also resolved that casual leave for the period more than 5 days stay should not be allowed. No, my lord, it's very clear because this was a general problem, my lord, we have taken note of. And we have made it clear categorically, just online is not enough. My lord, when, my lord, partially it was lifted, you are required to be in the station. Even if it is online, my lord, it has to be from Shillong, not from Calcutta. If you are supposed to do it Calcutta, my lord, at least you need a formal permission to leave the station. Her, my lord, initial was only for 3 days. Thereafter, we understand, my lord, lockdown. We never insisted.
So
now, my lord, this is very important.
You insist from which date they should be in station,
yeah,
which is
lord,
prevented by, you know.
I have annexed that, my lord. I'll just come to that, my lord.
Yes.
Now, my lord, what happened? This is the general decision taken by the highest decision-making authority, that is the Executive Council. Right. Generally for all, my lord. Now, my lord, he has challenged this, but he has never challenged this. This is not under challenge. So, whatever action is taken, my lord, based on these decisions, for all, on this resolution, we have covered all the aspects. This is never challenged. In his writ petition, he simply challenged, my lord, this granting of leave and, my lord, the rejection of the bill. Not this. Now, my lord, we'll come to the next speech. She has ultimately joined when, your lordship. 7 December, she wrote a letter to the university. In reference to your letter referred above, and in continuation of my earlier letters emailed as referred above, I would like to kindly inform you that I will reach Shillong on 10 December 2020 and will report department on 11 September 2020 and will submit my charge through proportion on 11 September 2020. I look forward your kind support and consideration. So ultimately, she joined, reported, my lord, on 11th December 2020. Now, my lord, this is the next resolution with regard to her case, my lord, 16 December. I don't think, my lord, I need to read. My learned friend has already read, because here, my lord, this decision has been taken by the EC based on its earlier general decision, my lord, taken by the EC. They said she will have to seek for leave. She was on unauthorized absence. Well, if I can read, it's not very long one, my lord. The council apprised that Balakishan Department of Geology, Nehu, was out of station for casual leave 23rd to 25th March 2020 after taking station leave permission from March 2020 to 25th March 2020 to visit her hometown Calcutta. However, the head of the Department Geology, Nehu, by letter dated such and such, informed that Balakishan is out of station on casual leave and station leave from such and such till 16 September 2020. And between Kishan has sent some email letters for grant of permission to work from home in view of the COVID-19 pandemic lockdown or other reason, and that the email letters have been forwarded to the register for necessary action. Now the department has started examination related besides other administrative responsibilities to faculty members, and therefore Professor B. Kishan's presence is required in the department and needful to be done at the earliest. The matter for absence negligence of duty was communicated to Balakishan from the establishment section by letter dated such and such, informing her that the authority has viewed very seriously not being present, report the department, and that she should report to the department immediately, latest by 12 October 2020, and submit her charge report through proper channel. She was further informed that her prolonged absence from the department till leave for the resumption of duty will be settled strictly as per the provision of the rules only after her joining the department. In the response to that letter, the Professor Balakishan has furnished her reply dated such and such that due to extraordinary situation spread of COVID-19 pandemic, she was compelled to stay back at Calcutta and carrying out her duties online from Calcutta, and that she furnished the entire assigned syllabus for the MSc and PhD casual courses, work classes online, and have conducted the internal assessment test and set the examination paper for the internal test and semester examination while working from home in Calcutta. Now, due to serious sickness of her aged mother, she is requesting to allow her to stay in Calcutta and extend her physical reporting in the department till such time the doctor advises that her mother is medically fit. Due to COVID-19 pandemic, she is requesting to allow her to take her teaching, learning activities online from her home at Calcutta and to allow her to take leave as permissible under Nehru rule. The council has further apprised that the Belacation has reported to her duty on 11/12/2020 and submitted the charge report to establishment. The council resolved that establishment section will examine her leave application as per the existing rule, withholding her salary from the month of such and such period. The council resolved that establishment will examine and take action. Now, this resolution is also not undertaken. Other thing, my lord, this follows. First, there was a decision generally.
Was the resolve to examine her leave application. Then what happened after that?
Now, my lord, her application was examined. She filed an application. My lord, she was suggested, my lord, what are the leaves available to her. That is at page, my lord, 28, annexure 10. Now, my lord, these were the leaves. Lordship, if you look into the brackets, number 1, earned leave for 18 days. Now, my lord, we have considered to be on unauthorized list from 28/5. 28/5. Not those period immediately during the COVID, my lord. When the my lord, restrictions were partially lifted, transportations were partially opened, my lord, from then only 28/5 to 2020 till 14/6/2020. That is for my lord 18 days. Then again for 54 days from 11/7/2020 to 2/9/2020. But while doing so, my lord, there was a summer vacation. My lord, we have excluded that period of summer vacations. Now next, my lord, half pay leave. Now the remaining leaves were granted, my lord, half pay leave for 99 days. This is the period from 3/9/2020 to 11/12/2020. Now, my lord, she has filed an application. Next, her application I have annexed your lordship 11. She has filed an application seeking for leave. But she realized, my lord, she has done a wrong. Without permission, my lord, number 1, just teaching from Calcutta is not enough. If she continued to remain in Calcutta, she needs station leave permission.
What happened to the other professors?
My lord, we have taken action against all.
All have got
This is not the question. It is
similar,
not his case.
Similar.
It will open the floodgate. No, it is not his case. Otherwise, I would have answered that any discrimination has been made out. But that is not in his pleadings. Otherwise, I could have placed these records.
Mr. Sharma.
And my lord, other thing, your lordship will appreciate one thing. She has filed this application after this was regularized, after she got her retirement benefit, after she has, she has retired. After retiring, she is filing this application.
So, my lord, may I just submit here, my lord? The person has, there is a different case that's been pending. That is with regard to her regulation. My lord, that is nothing to link with here this. Because, my lord, this is with the period of the earn.
That is regarding after retirement, whether she will be governed by new pension scheme. My lord has decided.
Or the old pension scheme.
Old pension scheme.
My lord,
after retirement.
That's regard to the judgment of this honourable court itself.
No, this is pending. One case your lordship has
that is pending.
Dijan Sharma. No, but that's a different.
Dijan Sharma, the similar lines. So, my lord, this is with regard to that.
You
how
appeared
have
in
been
that
she
case
been
of Dijan Sharma. Yes, same lawyer appeared.
Yes, my lord. My lord.
Yes. But so far, Dijan Sharma is in service.
Yeah, Dijan Sharma is in service.
This lady is already retired.
She has retired.
When did she retire?
Yes, my lord. My lord, she had to take voluntary she had asked for voluntary retirement, but she could not got voluntary retirement. Because of that, she had to leave the. That's why she resigned.
No, she resigned.
But my lord, this period of.
She resigned, madam. Sorry, 22.
Oh, she resigned.
Because, but my lord, this period which she has been treated unfairly. Because my lord, my learned senior counsel have been submitting here that I have not been given application to extend my leave. I have been given application to extend my leave. That is at page 66 of my writ petition. That is at page 73 of my writ petition. And my lord, may I just submit, my lord?
Yes.
My lord, this period which they have been calculating.
No, the thing is that another thing, see, Mr. Sharma, is that
yes,
you have not challenged the root of the impugn order. That's the only thing.
My lord,
that impugn order communicates the sanction of of that leave for you, and then not considering your other applications. But then the root is the resolution
My lord, that resolution was never communicated to us. The 12th December, was never communicated to us. The resolution, my lord, the resolution was taken from the resolution and order has been. No, my lord,
This is not a
I may
private
not be.
document.
My lord,
Now these,
my lord,
these,
an order
these
has been.
resolutions, listen, of the Executive Council, are they in the public domain?
Yes.
That's correct.
Yes, it's in public domain.
All professors
Yes.
are aware of it.
Yes.
Whatever.
Yes, my lord. Yes, nobody has come.
My lord, no, my lord, the resolution which my learned senior counsel has been talking about, that is in respect to me. And from that, my lord, after the resolution, an order has been passed. So my lord, the ultimate order and the ultimate leave application which has been rejected, the finality has to be challenged. And that will
Finality
take
you
up
have
into all into
challenged, but
consideration.
the root of the finality is not challenged.
My lord, I have challenged the entire finality, my lord. The entire finality where my leave application has been rejected. I have been working, my lord, in the entire period I have been working. There was a COVID situation. There was an online COVID situation was there.
What about
the state of Meghalaya?
See, what about this? There are these pointed letters that say that even work from home means work from.
No, my lord. The resolution
work
which
from
my
station. Work from station. Work from home doesn't mean. They said that is the letter. Where's that, Mr. Sen has shown it?
Yes, my lord.
Not resolution.
My lord, that letter. Yes, resolution says. My lord, may I read it? May I read it?
Station. Another factor is that you never asked for extension of your station leave.
I have, my lord. At page 66, at page 73 of my writ petition, I have.
Which date?
My lord, may I just come to page 66, my lord, my writ petition. Page 66, 9th of October, my lord.
No, we're talking about immediately after. Not 10th of October, because 10th of October you asked to join. When was that?
My lord,
after 5th
9th of October. Yes, on 9th of October I gave my letter, my lord.
Exactly. That is what this court is
saying.
Yes,
my lord.
After your station leave expired 25th, you never applied. It's only after you got a letter from them on 5th October that you applied.
My lord, my entire communication with the HOD was with that to allow me to work from home. So, my lord, no, my lord, it has been there. I will show it to you, my lord. My lord, at page 38, Annexure 8.
We'll take too much time in this case.
Page 38, my lord.
Period from March to May, they're not disputing. They're allowing you that. Correct. It's
No,
only
my lord.
thereafter.
My lord.
Where's that thing?
Yes, my lord.
Yes.
My lord, may I just show you? My lord, I may just show you this, my lord. At Annexure 1 of my affidavit in reply. This is the unlocked phase 1.
Round and round in the same place.
No, my lord, I'm not going. My lord, may just submit. My lord, let me submit. My lord, my lord, my lord may see the situation here. I was stuck in Kolkata because of the COVID restrictions. Was I not coming to duty because of my own negligence of duty? It was a pandemic situation, my lord. There was restriction all over. In fact, my lord, at that hour of time, there was a restriction of Meghalaya different, Assam different, West Bengal different. And the time I left the station, I left with the proper permission. The unlock one started happening from page 21, my lord. My lord, page 21 of my affidavit in reply, my lord. May I read, my lord? Page 21, Annexure 1.
Enough. I think you can submit your
My lord,
brief. We'll decide this.
My lord, let me point, just give me 5 minutes, my lord. I'll just show it to my lord that the unlocked 1 and unlocked phases that my learned senior counsel has been talking about, at that time there was entire restriction. My lord, guideline of phase reopening 1, unlock 1. School, college, educational training constitution will be open after consultation with the state government. It may hold at an institution level with parents and other states. Based on the feedback, the decision of the reopening of it will be taken in the month of July 2020. Phase 2, page 21. Till July 2020, there was
Mr. Sharma,
restricted.
Listen.
Yes, my lord.
We are concerned only. See, you went in March, find the lockdown was there. You stayed at home.
Yes, my lord.
Then find it
Yes, my
went
lord.
on. Then finally there was a relaxation. So when the relaxation was there, what steps did you take to apply for a continuous station leave or to teach from home, from Calcutta? Okay, that's not there. Only in October 11th, after you receive a letter from them, 5th October, and pursuant to the resolution, then you started agitating to say that I've been taking classes from home. So that's the only thing.
So, my lord, my reporting officer is the HOD. When I was asking permission of my HOD that shall I conduct online classes, he was giving me permission. He was assigning me works. So I was on a firm belief that my classes would be taken. So here, my lord, when I have been taking classes, and my lord may see the leave period. It is 28/5/2020 to 14/6/2020. This was during the lockdown. My lord, the office order states with effect from 28/5/2020, 14/6/2020. 18 days.
Yes. You give a bullet point.
My lord,
so you're not present physically. Give a bullet points, we'll decide. You file it within 10 days, yes.
But she resigned in 2020.
My lord,
2020 after resigning, she filed this. She filed the application. She could have challenged it straight away. She never challenged.
Yes.
No,
And my lord, it will open
my
the
lord, I had given my leave.
Publish.
My lord, before my lord passed away the record, after I gave my leave application,
You file a bullet
after
points.
I gave my leave,
We'll decide. Let the court think about it. Yes. Just after 10 days, filing bullet points. Yes.
5.
Much obliged.
Yes.
I'm praying for some admission for today. As a
It's
senior
supposed to come
counsel,
instructions today.
senior counsel is unlike your worship. He's engaged in one part of the matter. I'm praying this matter may come after 1 week.
Second half is infructuous.
Your Lordship, because election has been conducted and a new...
Let Mr. Changreso come. The second half will sit. Other matters are there. Yes. Then we'll get to rice. On meeting of the जाओ तुम जाओ के वहाँ
Milord, if I can make a mention, Milord.
Yes.
Milord, item number 23, Milord.
We are supposed to do it today and on your insistence.
Milord, yes, Milord. Some personal, I have a personal commitment, Milord.
That,
Yes, yes. Oh, my friend, tomorrow will it be convenient for you?
Tomorrow will be difficult, sir.
Because
what remains in this case, sir?
My lord.
You are at the other side.
Your Lordship.
What is your prayer in the morning?
Your Lordship,
That's being settled. They go for arbitration.
No, Your Lordship, it's for the petitioner to come with
So you come in
I will apprise your Lordship. But it will be taken tomorrow, Milord, or day after, one of these days.
Your Lordship, Mr. Paul won't be available this whole week.
Okay, Monday.
Milord, I'll be away from Monday.
Only instructions whether you will go for arbitration or not.
No,
leaving aside everything else.
Milord, I'll make my written submission. My friend will submit.
Then we'll take. When are you available? You're going for. He said you're going for 3-week vacation. Which he
I'm
mentioned
going to Delhi for a treatment.
Oh.
On the 15th, I'll be here after the 15th.
After 15th of March. Then we'll take it after that, since you waited for so long.
After.
Yes, and we'll list it after 15th of March. Any date, yes.
Okay.
Yes.
Item number 25, my lord. Mr. Jha.
Who's the 25 other side?
Mr. Jha.
Om Prakash Rao. Yes, Mr. Jha.
My lord. It is for the instructions.
What instructions?
This is regarding pension, my lord. They've come after many years. So,
disability pension.
You are banking on that Himachal Pradesh judgment?
Uttarakhand.
Uttarakhand, sorry.
Not Himachal.
Same difference, yes.
Some more
Yes,
time.
yes.
Some more time, my lord.
2 weeks, okay. Yes. Mr. Pandey.
I beg to mention item number 31, Lordship. If it may come after a week.
31?
31, Lordship.
Okay, 31 1 week.
Hello.
Miss Wanyang. 31, yes.
Yeah, please, Lordship, I beg to mention item number 27.
20?
27.
It's already been mentioned.
But you haven't allowed.
Oh, you've informed them?
Yes, Your Lordship.
Okay, 2 weeks. Yes.
Lordship, I have a small prayer, Lordship. In item number 1, Lordship, in supplementary list, Lordship was pleased to fix the date on 20, 21st and 22nd of March, Lordship.
Yes.
That date, Lordship, is clashing with arbitration proceeding, Lordship. So, Lordship, I am praying if that can be fixed on 26, 27, 28 of March.
That whole week, this High Court will be closed. The holiday list has been reshuffled.
Any date after that, Lordship?
You go to April.
Because, Lordship, the problem is it's clashing with...
You're the petitioner, correct?
Lordship.
You have to be... Okay, then you inform the correct the dates to the court master. Yes. In April.
April, Lordship.
Yes.
Hello,
Yes.
I'd like to mention item number 24.
Item number?
24.
24. You have come especially this matter today, you know? So we'll finish it off.
Lordship, actually, Lordship, I have some engagement.
Engagement?
Lordship, some personal engagement.
Okay, 1 week.
Monday, Lordship, let this matter come on Monday if it is possible.
Yes. Yes. Come here, yes. We'll take it up tomorrow. You come with
Lordship, I'd like to mention item number 32.
Your item is that you inform.
Item number 5 of the
Supplementary. Yes?
Item number 32, Your Lordship.
Item number?
Item number 32. I prefer 2 weeks time, Your Lordship, for
32.
filing rejoined affidavit.
No rejoinder affidavit. It will be just 1 week. Yes, where's Mr. Devnath? Yes. That's it. No other matters for the second half?
29, 30.
You're ready for that, 29:30. You'll want to take it up. Mr. Nongpur, you want to take it up? Yes, 29:30. You'll take it after lunch.
26 also.
26 also. Where's Mr. Bora? How many matters left?
26, 29, and 30.
26, 29, and 30. Okay, we'll take after lunch.
After lunch at 2:15 or 2 Lordship?
Yeah, 2:15 because there's a meeting now regarding that thing. So, yes.
Lordship.